can continue to sit and argue.
Lord, I'll try the podium first if I have difficulty.
Do that because if you it will unnecessarily put pressure on your.
That's fine.
Yesterday, in about half an hour, 45 minutes, you were under distinct discomfort. Right. So you can sit and argue. There's no difficulty at all.
Let me do the podium.
All right.
I felt embarrassed yesterday.
Dr. Dhawan, yesterday you made an important point, I think, on the interpretation of Article 30, because Article 30 uses the word the right to establish and administer. Every minority, whether religious
yes.
or linguistic, will have a right to establish and administer. Establish, you said, takes you to the founding moment. Establish should not be confounded or conflated with existence.
Yeah.
And I was just reflecting on that. That has some element of importance and great deal of importance for this reason, that there may be a number of circumstances which are necessary for the existence of the institution, but don't go to the establishment of the institution. For instance, no institution can exist without a grant of land. You cannot construct if you don't get land. So your existence is dependent on the lease which you get from the state government or the central government. Second, you may not be able to function if you do not have in today's times aid. So your existence may be conditional on the nature of the aid which you get. Third, apart from this, you need recognition and affiliation. Without recognition and affiliation, you will be only a shell. You have to award degrees. Right. So all these aspects may be relevant to the existence, the viable existence of an institution, but they have no bearing on the establishment of the institution. Establishment, you said, therefore, goes to the founding moment. Look at who founded, look at the history, look at the antecedent circumstances, and determine who really established the institution. In other words, establishment takes you to a point of time in the past. Administer is not really confined to a moment of time in the past, and that's the distinction I wanted to make, and I said I'll put it up right up front. Administer is a continuing facet. Establish is one time, who set it up. Administer is something which is a continuing exercise. So who is actually in management of the institution? Administer, one can broadly say, can be equated, or you can derive some sustenance from the nature of the management. Is the management of that institution in the hands of a minority? And finally, the point which you made was that merely because an institution is regulated by a statutory provision, a statute gives it the color of an incorporated body. A statute regulates various aspects of its existence, does not take away its minority character if the other parameters are fulfilled, namely the establishment and the administration. I think that
I think is the point, my Lord. But let me make it clear that I've said so that these institutions must be institutions of excellence. They must accept regulation. All kinds of secular regulations you must accept. That is what TMA Pi says, my Lord. That is what is said in Kerala. And therefore, when we look at administer, your Lordship put this question to me yesterday, that it can't be 100%. It cannot be, my Lord. In this day and age, in liberal education, a student body comes to you and says, we want to be there. You accept. The old boys come, they say, we want to be there. You accept. Now, these are big changes, my Lord, in the concept of administer.
Teachers have to be represented, for instance, in the management council by statutory provisions.
That's right.
A certain number of representatives of the teachers have to be inducted in the management council.
Absolutely, my Lord. And one has to accept this. Gone are the British days, my Lord, when you did this or did that. Under the Constitution, you have to accept this. That is the point, my Lord. And no minority can say, we don't accept this.
So the mere fact that some part of the administration is also looked after by non-minority candidates who have a representative voice by virtue of their service in the institution or their association or engagement with the institution will not, in that sense, dilute the minority character of the institution.
And as Gandhi Faiz-e-Azam says, if other people come in there, what's wrong with it? Of course, there was a dissent, but that's a different matter altogether.
But it can't be to the point where the entire administration is in non-minority hands.
Quite right.
We may not be able to lay down a numerical test, 50% of the administration or 60%.
That is late.
It will be very dangerous to do that.
It is.
It must be more in the nature of a qualitative test. Is the true essence of the administration such that the minority continues to be in...
And the converse of that argument is the government should not interfere. That is what is said in TMA.
And finally, when you are wrapping up today, we would like you to tell us what are the indicia of administration to indicate that AMU continues to be administered by a minority?
Milord, what I show to your lordship is what was there in the 1920 Act is replicated in the 81 with some changes which are important.
Right.
So all that, the old boys are there, the several institutions which are Islamic are there, all that is there in the governing.
Because we will have to also meet the test of is AMU administered by a religious minority?
Right. Well, what once goes to the government, the governing board, are they there or not there? Well, as a wit said in New York, is the there? And I'm going to answer the there is there. May I just, my lord, first outline what I'm trying to do?
Dr. Dhawan, would you be able to wrap up today by 12 o'clock? So
Yes,
that,
yes.
By 12 o'clock?
Yes, my lord.
Then we'll give Mr. Sibal time until 1 o'clock. And then the others can, complete in rapid fire, because we'd like to wrap up the arguments on this case by tomorrow evening, because this bench is not available next week. But we'd like to conclude the...
Lord, that's up to your lordships, how much time we get.
As we were discussing last evening, you have covered almost the entire, you'll be covering almost the entire ground. Then the others would maybe throw in whatever they want to say apart from...
Well, the other side must have time to present their case, and that's
we'll
very
important.
Be able tomorrow. May not be able to, my lord, because
rather important.
this would, my lord, it's a 7 judges bench, my lord, going down the history, my lord, and some of the facts, which obviously, my lord, I'm not as a criticism saying, not placed before your lordships, but we may have to place before your lordships. Lord, that may, my lord, we make, my lord, because we will not repeat anything, my lord. Let us say will not repeat. There are many things which we'll have to place.
We'll see.
Dr.
Dhawan, will
Miscellaneous in the morning, and we can assemble in the afternoon and then wrap up on Friday.
My lord,
Possible, because
Lord, it may spill over next week, my lord. Your lordships may consider.
next week bench is not available, so we'll then have to take it the following week.
I thought because of the other bench, my lord, your lordships.
No, next week. In fact, the other bench is because this bench is not available next week.
Oh, I'm so
One of the colleagues is not available next
my lord,
week.
genuinely, not to stretch it, my lord, but it may not be. We had a meeting, my lord, and what are the points to be urged, my lord, we have internally discussed. But realistically speaking, my lord, it may not be. It will not be possible, my lord, on this side.
All right, let's start at least.
I leave it to your lordships
Yes,
to
yes.
work out the time, my lord.
Yes.
But it would be required.
Dr. Dhawan,
My lord,
Brother Khanna,
I'm sorry I've taken so much time.
no, you're welcome. In fact, we did hardly interrupted you yesterday.
Lord, the person who starts a case, my lord, is like Sunil Gavaskar. After it is established, you can be Virat Kohli. All these people are Virat Kohlis. Now, my lord, let me just summarize what I'm trying to do, my lord. My lord, my arguments so far have been as follows. Let me just outline the arguments and then I can go fast. My lord, my first argument, my lord, was the preliminary argument about change of stance. My second argument is the one that I'm canvassing now, which is Aziz Bhasha internally contradictory and superseded by some other decisions? That is what I'm doing now. And in our submission, it's going to be that Aziz Bhasha is no longer good law. That is apart from your Lordship's interpretation of 30. So at present, I'm occupied with the question, was it internally contradictory? Did it look at the other aspects of the Act on purpose? No, it didn't. And then look at the later decisions, starting from, do these decisions end up by saying that Aziz Bhasha, or asking your Lordships that Aziz Bhasha is no longer good law? I showed to your Lordships that in St. Stephen's, Aziz Bhasha is mentioned. But in the next paragraph, they say it's been superseded.
Next paragraph.
It's been superseded. Patro, etc. is mentioned. They said, however, we must look at this. So, my Lord, this is what I'm trying to do. The next stage will be to look at the statutes. Statutes arising out of the reference, which is UGC Yashpal and National Minority Act, Education Act. And then, my Lord, I have some things to say about the Allahabad judgment. Your Lordship is not deciding the appeal, only the reference, my Lord. So this will be my framework.
Right.
Now, my Lord, I come to St. Stephen's, to TMA. Because, my Lord, in our respectful submission, after all these decisions, Aziz Bhasha is dead and buried. My Lord, your Lordships will kindly come to volume 5A. And it starts at page 552. I will take your Lordship straight away to 606. Now, my Lord, your Lordship has noticed in Aziz Bhasha that the Lordships, my Lord,
चेतन हल्का सा पंखा लगाओ क्योंकि
it's curtailing time. It's okay. In Aziz Bhasha, Article 26 was noted, as I showed to your Lordships. But they said if you've lost your right under 30, 26 is irrelevant. Now, TMA Pi at page 606. I won't read all of it, my Lord. It effectively says that 26A is also the right that minorities have. But that is a right that is given to both minorities and others.
which is the para that you want us to read at 606?
26.
Para 26.
So this is now settled that both the majority and the minority have rights under Article 26. That's important. Now, my lord, kindly come to 613.
That's how Orwell got the benefit of 26, right?
That's right, my lord.
And Orwell, 26 has nothing to do with your minority state.
Absolutely, my lord. If
The
there is a
Pinapaledi's
majority, for example, in UP,
Pinapaledi's judgment on Orwell was about 26.
absolutely right. Now, my lord, in the state of UP, if the Hindus are in majority, they can resort to 26. That's important, my lord. The majority also, my lord, has a stake in 26. And that is how the Constitution has to be read. Then, my lord, may I take your lordships to page 615? Sorry. I'm sorry, my lord. 613 is very important. In this, my lord, TMA Pi fleshes out what the meaning of the right under 30 is. It's now fleshed out now. Come to 50, my lord, para 50, page 613. And on this, everything turns. Your lordship then? It says the right to establish and administer broadly comprises the following rights: to admit students, to set up a reasonable fee structure, to constitute a governing body, to appoint staff, and to take action if there is any dereliction of duty on the part of employees. This is what the rights, as I said, my lord, the antecedent aspects are different, my lord. What are the rights that come under establishment? This has now been established by your lordship's court. This is very important.
Mr. Dhawan, sir, 50 would necessarily relate to minority. The
No.
right to establish and administer broadly comprises the following rights. All these rights are of the minority.
My lord,
Has to be
in
of the
respect of
minority.
29 and 30, my lord.
In respect of 30,
30.
they were dealing with 30. So therefore, the minority institution would have the right to admit students. Minority institution would have the right to set up a reasonable fee structure. All these A to E are relatable to minorities.
Yes. Yes. See the heading. I'm sorry.
Unaided non-minorities.
That's right.
Because once you hold education as charity and you bring in Article 26 Clause A, then they're dealing with non-aided, non-minority institution. In that, under 50, they've given the power, the rights which they have the right to administer.
My lord, as far as aided is concerned, they say that you can't have maximum autonomy. But at the same time, the regulatory framework will apply to you. And therefore,
As Brother Dipankar Datta said, para 50 applies only to minority institutions. Otherwise, what will happen is that the rights which are conferred on a minority by para 50, recognized as inhering in a minority, will also inhere in a non-minority institution. That can't be so.
Heading above para 48.
That says private unaided non-minority education institution.
So that forms part of this heading.
But I think.
well, let me take an example. Suppose there is a non-minority institution. The control of the government is much greater.
Of course.
Has to be. Because of, if your lordship will see the heading of this private AD, not, and my lord, both Inamdar and TMA Pi say aided institutions don't lose their right. Just the regulation is more. The question was, my lord, in Inamdar, the question was, how do you have to give seats to the government? They said, as far as unaided is concerned, it's you give it or not is a matter of negotiation. As far as aided is concerned, seats will go. Because that assume a lot of,
But a non-minority institution cannot say that, well, I'm entitled to admit students at my choice. If you are not if you are a non-minority institution, you can't say, well, I will only admit whatever students I want
yes,
from my denomination
yes,
or for people of my liking. The right to admit is given only under
Absolutely.
Article 30.
Absolutely.
And even that is subject to the restrictions that St. Stephen's has imposed.
That's right. I don't not quarrel with that proposition. St. Stephen's is a little more liberation because it says, although the act is there, it doesn't matter, we will protect your discretion. And that is the significance of St. Stephen's. Now, my lord, may I take your lordships?
Just 1 minute.
Lord, I'm now in Virat Kohli. I have to rush through this, my lord.
Yes.
Now, my lord, kindly come to page 615. my lord, para 54, which is relevant to your lordship's, my lord, summary this morning. The right to establish an education institution can be regulated. Such regulatory measures must in general be to ensure the maintenance and proper academic standards, atmosphere, infrastructure, including qualified staff, and the prevention of maladministration by those in charge of the management. The fixing of a rigid fee structure dictating the formation of composition of a governing body, compulsory nomination of teachers and staff for appointment for admissions would be unacceptable restrictions. So, my lord, the general law will lie. The moment you intrude, my lord, that's why the balance is upset.
Yes.
Now, my lord, kindly come to 621. My lord, just above para 71. At placetum D, it has been held that the conditions for affiliation or recognition which pertain to the academic and educational character of the institution and ensure uniformity, efficiency, and excellence in educational courses are valid. But they do not violate even the provision of Article 30. But conditions that are laid down for granting recognition should not be such as lead to governmental control. Then, my lord, 622, I'll briefly, just above paragraph 73. It says at the same time it has to ensure that even an aided institution does not become a government-owned body and controlled institution. Neither aid, normally the aid is granted is relatable to pay and allowances of staff. Indeed, the management of private aid institutions has to incur a revenue. Such aided institution cannot obtain the extent of autonomy in relation to management and administration as would be available to private unaided institutions. But at the same time, it cannot also be treated as an education institution departmentally run by government or as a wholly controlled government institution to interfere with the constitution of the governing body and staff. Now, my lords, page 623. What is a minority, my lord? This has now been settled. It may not be relevant, my lord, for your lordships. That is para 76, my lord. If therefore as your lordship there,
Yes.
the state has to be regarded as the unit for determining linguistic minority vis-a-vis 30, then with the religious minority being on the same footing, it is the state which in relation to the majority that will have to be determined. On page 624, my lord, at para 79, this is affirmed. There can be therefore little doubt that this court has consistently held that with regard to a state law, the unit to determine a religious and linguistic minority can only be the state. Of course, we prefer, my lord, Justice Rumapal's decision, which says it depends on the statute. Now, my lords, 85, my lord, on page 625. As I'd argued before another bench, my lord, that although basic structure applies to constitutional amendments, after Bomai, you take some aspects into account while interpreting the provision. So, my lord, 85, secularism being one of the important basic structures of our constitution, Article 27 provides that no person shall be compelled to pay any taxes, proceeds of which are specifically appropriated for the payment of expenses. My Lord, I forgot to mention one other aspect, my Lord. Where is that thing? Business about. My Lord, I forgot to mention one thing, my Lord. May I do it now, my Lord? Because secularism is an important part of this judgment. And there are very eloquent provisions, my Lord, statements at the end. My Lord, may I take your Lordships back, my Lord, to page 616, para 57? I'll just summarize it. Has your Lordship got it, my Lord? It says that charitable institutions can't be run for profit. And at the bottom of that, my Lord, there can, however, be a reasonable revenue surplus which may be generated by the education institution for the purposes of development of education and expansion of the institution. You claim minority status, you become charitable, you can't be a profit-making institution. Now, my Lord, I was on para 85. Now may I come to para 89?
Dr. Dhawan, can you just repeat the sentence which you said just now?
My Lord, what this court says, if you are a charitable institution, which you would be under Article 30, you are not institutions of profit. Not necessarily. You have a revenue surplus, you expand your institutions, but they're not profiting maybe. And this was a concern, my Lord, arising out of Undi.
Was this said in context of Article 26 or Article 30?
30. It would apply to 26 as well.
It will apply to 26 as well, because 26 uses the expression for religious or charitable purposes.
That's. I want to flag this, my Lord, because this is something that the minority institutions must accept. Education has become a profit-making exercise. This court says, claim charity, you are not. And we accept that. Now, my Lords, may I come to 85, which I've read. Secularism, I'm sorry, is your Lordship on 85? No?
Yes, you got it.
Your Lordships are whiz kids, my Lord. Your Lordship can go from one to the other. Secularism being one of the important basic features of our Constitution, Article 27 provides that no person should be compelled to pay any taxes, proceeds of which are specifically appropriated for the payment of expenses for the promotion and maintenance of any particular religion or religious domination. Now, my Lord, what it says about 29 and 30, page 626, paragraph 89. I'll come there. So, my Lord, it says Article 29 and 30 are a group of articles relating to the cultural and educational rights, and then it analyzes what 70 does and 30 does. Then, my Lord, a very important aspect in para 93 at page 627.
Actually, see, para 91, that makes the distinction between Article 26 and 30
That's right.
clear.
That's right. And it says it applies also to majority institutions, 26. I should have placed that.
Dr. Dhawan, therefore, you're arguing that to get protection under Article 30, the institution must be run as a charitable institution.
That's right. And that's laid down.
No, I'm just asking as,
Yes.
as a matter of...
That is the majority judgment.
That will be the third exception which you have required.
That's right. That's right. Absolutely. And an 11-judge bench majority says so, Lord. Who am I to say anything else? And it's all subject to reasonable restrictions. That your Lordship will bear in mind. Now, my lord, may I come to para 93, my lord. Can Article 30, I'm sorry, my lord.
Yes.
Can Article 31 be so read as to maintain that it contains an absolute rights of minorities, whether based on religion or language, to establish and administer educational institutions in the manner they desire, without being obliged to provisions of any law? So this, my lord, is elaborated then cases are, Lord mentioned. 629, para 98. It is clear from the aforesaid discussion that this court came to the conclusion that in the case of minority educational institutions, to which protection was available under Article 30, the provisions of 29(2) were indeed applicable. You can't force, if you've given aid, you can't force people to attend. As I gave a personal example that when I went to a Christian institution, they asked my father, should he attend chapel? And he said yes. And I was the better for it. I still couldn't sing Christmas carols, but that's another point altogether. Now, my lord, if your lordships will come to 109. I'll quickly run through this, my lord. What decisions are affirmed by TMAPI? Mother Provincial, my lord, is affirmed in para 109. Now, my lord, it goes through St. Xavier's from 113. It's an important decision, my lord. I didn't go through it because TMAPI supersedes it in some. Now comes, my lord, the famous dual test that was there in Siddharth. That your lordships will find on page para 122 on page 641. I'll read, my lord, para 122 from F. My lord, the English don't say placetum, they say place. The regulation must satisfy a dual test, the test of reasonableness and the test that it is regulative of the institution, to making the institution an effective vehicle of education for the minority community or other persons who resort to it. One of your lordship's questions yesterday was about this. It was permissible by the authorities to prescribe regulations which must be complied with before a minority institution could seek or retain affiliation and recognition. But it was also stated that the regulations made should not impinge on the minority character. This is, my lord, in the last line, that it says a balance must be obtained, and the lordship say at the end of that paragraph, in our view, this is the correct approach. I won't labor too much on this, my lord, but para 124, because I haven't cited those decisions. I'll briefly, my lord, indicate what it is. The decisions that are important, my lord, are mentioned in para 124. For example, Lily Kurian, Constitution Bench, if you have to go to an outside authority like the VC, they said, I'm sorry, that's bad. Then Christian Medical College applied the industrial law. Gandhi Feza Azam says that you can have, my lord, the principals, senior most teachers. And of course, now we have, your lordship put it, my lord, if students come, they have to be on the board. Then, my lord, if I may take your lordships to how St. Stephen's was dealt with. It starts at 125. I won't read the paragraphs that are approved because I've given them to your lordships. Your lordships will find that, my lord, on page 444. 644. And then, my lord, your lordships will see para 9. Para 127, my lord, on the right to select students. The university regulation said that you must have our criteria. Your lordship said no. It's a minority institution and therefore it's entitled to have its interview tests. Then, my lord, all that is mentioned, my lord, I come straight away that will continue, my lord. The 135 is important, my lord. We agree with the contention of the learned Solicitor General that the Constitution does not give an absolute right. In Siddharth Bhai, they said it is absolute. So they said you have to take into account national aspects, and 134(6) decisions of this court have held the right to administer does not include the right to maladminister. 138 is important. It actually says, it sums up what St. Xavier's did. I come to 138.
Yeah.
It's important, no? As we look at it, Article 31 is a sort of guarantee and assurance to the linguistic and religious minorities of their rights to establish and administer educational institutions. Secularism and equality being two of the basic pictures of the Constitution. Article 31 ensures protection to the linguistic and religious minority, thereby preserving the secularism of this country. Furthermore, the principles of equality and secularism of the country, furthermore, the principles of equality and secularism necessarily apply to the enjoyment of the rights. No law can be framed which will discriminate against such minorities with regard to establishment and administration. This, my lord, sums up St. Xavier's. Then over the page, my lord, on 650, your lordship will see St. Xavier's is quoted. Then, my lord, page 650, bottom of the page, para 141. What your lordship puts, my lord. However, conditions of aid that do not involve a surrender of substantial rights of management would not be inconsistent with the constitutional guarantee, even if they indirectly impinge upon some facet of administration. If, however, aid was decided on the ground of an educational institution is under management of a minority, then such a denial would be completely invalid. Then, my lord, paragraph 143. This means that the right under 31 implies that any grant that is given to the state to the majority cannot have such conditions attached to it which will anyway dilute or abridge the rights of the minority institution to establish and administer that institution. So that's the balance, my lord, that is there in the dual test. Then, my lord, the Constitution debates are mentioned at 146 and 147 on page 653. We have, my lord, got in our submission aspects of the Constituent Assembly. I will not repeat it. Then, my lord, page 655. para 151. The right of the aided minority institutions to preferably admit students of the community when 29(2) was applicable has been clarified by this court a decade ago in St. Stephen's. While upholding the procedure of admitting students, this court also held that the aided minority students were entitled to preferably admit their community candidates to maintain the minority character of the institution. And then, my lord, at Placitum E, thus St. Stephen's endeavored to strike a balance between the two articles. Now, my lord, on secularism, my lord, there is a very evocative passage on page 657, which I'll read to your lordship. It captures the diversity of India, my lord, and its importance. My lord, para 157 on page 657. For the healthy family, it is important that each member is strong and healthy. But then all members do not have the same constitution, whether physical or mental. For harmonious and healthy growth, it is but natural for the parents and the mother in particular to give more attention and food to the weaker child so as to help him and her become stronger. Then, my lord, just Placitum D, all the people of India are not alike. That is why preferential treatment has been given. Is not frowned upon by Article 30, which is a special right. Then comes, my lord, the evocative passage in para 158. The 1 billion population of India consists of 6 main ethnic groups, 52 major tribes, 6 major religions, and 6,400 castes and subcastes, 18 major languages, and 1,600 minor languages and dialects. The essence of secularism can best be depicted if a relief map of India is made in mosaic, where the aforesaid 1 billion people are small pieces of marble that go into the making of a map. Each person, whatever is her language, caste, religion, has his or her individual identity, which has to be preserved so that when pieced together, it forms a depiction with different geographical features. These small pieces of marble in the form of human beings, which may individually be dissimilar when placed together in a systematic manner, produce the beautiful map of India. The variations of color, as well as the different shades, are small pieces, my lord. And then, my lord, now, my lord, very quickly, the summary, my lord, at the end, page 658. Three B, my lord, which emphasizes of their choice. Then, my lord, in question 4 on page 659, I'll take your lordship straight away to D. A minority institution does not cease to be so the moment grant is granted by the institution. As your lordship said, my lord, it's a necessary condition. You can't survive without it. Then, my lord, I come straight away to 661, my lord. Question number 8, whether the ratio laid down by this court in St. Stephen's is correct. If not, what order? The basic ratio by this court in Stephen's is correct as indicated in this judgment. However, rigid percentage cannot be prescribed. It must be left to authorities to prescribe a reasonable percentage. Then, my lord, question number 11 on 662, that it applies to postgraduate level. At some stage, my lord, when it was argued, TMA Pi before 7-judge bench, my lord, one argument made by Justice Anand was, don't have it for tertiary education. My lord, that has not been accepted. Now, my lord, I am done with this, my lord, and I'll summarize what I've said. In the light of these decisions, it cannot be said that Aziz Basha is good law. Therefore, my lord, whatever else your lordships may say, Aziz Basha is no longer good law. On that there can be little doubt.
Dr. Dhawan, how would you summarize as the essential foundation of Basha? And how, to what extent is Basha now overruled by, implicitly, of course, by...
Lord, our respectful submission was in two areas. Basha said that if there is an intervention of a statute, then you lose your character as a minority institution. Second, my lord, Basha is contradictory because it says a university can be a minority institution. But the intervention statute is there, so it can't.
Sorry, can you just repeat the second part?
Institution can be an
My lord, it says that minority institutions include university. But then, my lord, where there is an intervention of statute, you lose your rights. Now, my lord, all the decisions that I've quoted go against that. The third aspect, my lord, that I indicated to your lordships was that Aziz Basha did not look at the whole act to look at the purpose of the act. Of course, AMU was not a party with us, a different matter. So, my lord, the purpose of the act, when I took your lordship to the 1920 Act, is clearly, as the Allahabad bench put it, green. And the purpose of the act has to be looked at. This is adding to my argument on antecedent history. So Aziz Basha looks at the antecedent history and ignores it. Uh, 4A.
So now, Dr. Dhawan, you have covered your second point in the framework.
That's right, my lord.
Now we go to
Apart
the
from the
third.
preliminary, I have covered the point. Aziz Basha and the later decisions.
Now we go to the third aspect, which is the analysis of the statute,
Statute.
UGC, and then
Now,
after
Aziz
that-
Basha, my lord, through Yashpal, indicates the UGC Act. And, my lord, it also recognizes the National Minority Education Act. I want to quickly place those before your lordships.
Right.
My lords, kindly come to 4A, volume 4A.
I was to you.
Right.
What we would really like to have is a clear analysis of how the 1920 statute has unfolded,
Yes, sir.
the original provision, and what is the effect of the amendments.
Yes. Sir.
Because let's look at, then we can go to UGC and
No, I'll finish this in 2 minutes.
UGC and
Yes, yes, yes.
all that, and then we'll, because that is to our mind very crucial.
Yes, yes, my lord. The amended act.
That chronology I am going to give in my own way, my lord. That's why, my lord, if
I always respect the solicitor's own way, my lord.
Yes.
Now, my lords, very quickly, my lord, so that because it arises out of the reference, we must place it.
Yes.
My lord, art is long and time is fleeting. I realize that, my lord. Now, my lord, page 203,
2 or 3.
volume 4A. It says university means a university established or incorporated by or under. So the way these arguments were not accepted by this court is it should be by and under. This is Yashpal. So I'm dealing with that. And includes any institution which may in consultation with the university be recognized by the commission in accordance with the regulations made under the act. Then, my lord, I'll take your lordship straight away to section 22, my lord. (22(1), my lord, on page 214. The right of conferring or granting degrees shall be exercised only by a university established or incorporated by or under a central act, a provincial act or state act, or an institution deemed to be university under section 3, or an institution specifically empowered by act of parliament to give degrees. This is the statutory position. It can't stand in the way, Milton, of Article 30. Then, my lord, I don't want to just flag 23 and 24, that if you don't do all this, you'll be punished. Now I come very quickly, my lord, to the Minority Act. This is in the same volume, page 227. 221. Doesn't matter, doesn't matter. If the UGC Act is seen, it'll have to be by statute. And if this is taken out of 30 subclause 1, my lord, it means all tertiary education except private institutions will not get the protection of
It
30.
will nullify the effect of 30,
That's
because every minority institution, once given a statutory recognition, will fall outside the ambit of 30.
That's right. Statutory intervention, my lord, will not be override 30. And that, my lord, is the problem in Aziz Basha. And that is why, my lord, it was heavily criticized by Sirwai and other people. I'll just give the pages of Mr. Sirwai's. I won't go more than that. Give me the pages. It's in volume 3G, my lord. I won't take your lordships to it. Page 185. And the judgment, my lord, St. David's is there. I've already argued that it's not a proposition which is correctly stated in Aziz Basha. Now, my lords, I come back to the National Minorities Act, which is in 4A, and I'm going to page 221. Just very quickly, my lord, I'm done with this act. Your lordship has got 221. Now, my lord, 2G. What is a minority educational institution? Means a college or educational institution established and administered by a minority or members. My lord, earlier in the original act, it said other than a university. That is not so anymore. In 2004, my lord, universities were not included. So G said other than universities. That now, as part of the amendment, my lord, is universities are included. I don't want to go back, my lord, to the original act. I quoted that in my written submission. Then, my lord, section 10, page 223. The heading is right to establish a minority educational institution, page 223, section 10. Subject to the law contained in any other law for the time being, any one person who desires to establish a minority education may apply to the competent authority. This is for the future now. Justice Nariman's judgment in St. Clooney looks at it. I don't want to go there. And then 11-24, the commission on page 224F.
Explain this to me.
what I'm saying is that Article 30 through this Act has been made a statutory right. Also, that is why I wanted to place it before your lordships, and it's in the reference.
The amendment to section 2F was, 2G was with effect from 1/9/2010.
Yes, yes. Now, my lord, I come to answer your lordship's question on the here now, 1982 Act. Then I'm done, my lord, apart from a few chutkulas. My lord, this is dealt with in my written submission at page 50, but I'll take your lordship to the Act first. The written submission, my lord, is comprehensive on this.
This line of statutory provision, where will we get them?
Sorry, my lord.
Which volume will they be in?
My lord, 3G, my lord. Page 30. We've got the book as well if your lordship wants
You
it.
can just look at the.
It's there.
It's the purpose of the provision to identify who is the minor.
First we come to. हमारा कहाँ है? हमारा ही है. I'm on the last leg, my lord.
Yes.
Now, my lord, the statement of objects and reasons, which is in another volume, my lord.
That we saw yesterday,
No, my lord, of the 82 Act,
of the 82 Act,
81 Amendment.
right?
This will be volume.
My lord, volume 4A at page 148, my lord.
Page, volume 4A, page 88, right?
Sorry, my lord, 148.
Okay. Well, should we look at the Act
Well,
first?
my lord, let's, because the purpose of the Act, my lord, has to be understood.
Yes,
And
we
the
saw.
Allahabad High Court actually struck down 3 provisions, my lord. because there were a usurpation of judicial power.
Yesterday we saw volume 4A, page 88.
That my lord is original act.
Right.
Now I'm on the 82 Act,
That was the SOR for the original.
81 amendment.
SOR.
For the original
Yeah,
act,
not the act.
not the act, only SOR for the act.
See the act.
Look at the original act and then see how that act has been modified by the 81 amendment.
I've already
Then we know
placed
what is
it.
deleted by the.
My lord, when I look at the act, I will refer to the original provision. Now, my lord, this statement of objects and reasons says, India is a multi-religious country and its strength lies in the fact that all communities in the
Volume
country,
4A,
page 148, 4A.
right. Yes.
Now, my lord, 148, it says, India is a multi-religious country and its strength lies in the fact that all communities living in the country are free to establish educational and other institutions of their choice. The government have introduced in Parliament an amendment to remove doubts in the minds of the Muslim community regards the character of Muslim universities, but the amendments of the Ali Muslim would be meaningless and would become redundant if statutes are not amended to satisfy the sentiments of the Muslim community. Now, my lord, I'll just take your lordship very quickly, my lord, to section 2. Section 2.
Yes.
My lord, section 2 adds to the preamble of the original act, takes away from the original act to add the words, to remove the words establishment and.
It's only incorporate.
Right. And the Allahabad High Court struck this down, saying it was a usurpation of judicial power. Parliament was sitting in appeal. Not before the court at this stage, my lord, but I have to go through the act, my lord, so I have to mention this.
But it's happening. This must be.
To two other provisions, my lord, straight away. Now, my lord, your lordships will see that in 3L, my lord, on page 148, university means the educational institution of their choice established by Muslims in India, which originated in the Mohammedan Anglo-Oriental College and which was subsequently incorporated to Leo's Aligarh Muslim University. This provision was struck down by the Allahabad High Court. Then, my lord, I come to 5.2, section 4, subsection C. In section 4. Yes, yes, German section, of course. Now, my lord, amendment of section 5 in 4 is to promote especially the educational and cultural advancements of the Muslims in India. This was struck down by the Allahabad High Court. Has your lordship got it?
Section 5.
5, my lord, the first part in clause 2, it says C, to promote specially the educational and cultural advancement of the Muslims of India. That is in section 4, my lord.
Section 5.
So 4C.
Section 4, amending section 5.
Right. The amending section 4, yes.
Right.
Are you challenging all the three striking downs or? the
No,
first-
these are the three.
No, the first two, you're really challenging the first two or the third one also?
No, my lord, I'm challenging everything. I'm saying no usurpation of the judicial power. I put it in my written submission.
Of course, that's not the subject matter of the reference.
Yes, yes.
This will be decided by the normal bench.
Yes, yes, no, I understand. I understand. But I'm placing it before your lordships to understand the 81 Act.
On that, entire matter is referred.
My lord, if your lordship is going to decide it, I'll need another day, my lord, which I don't want. So, my lord, may I just quickly take your lordship through the amendments? Because this will give your lordships an idea of what the changes in the 81 Act are. And then I'll quickly run through the 81 Act. May I proceed, my lord? Then, my lord, your lordships will see that
Change in 2L, which is made by the word, how was 2L earlier prior to the amendment?
there was no 2 years.
There was.
There was a 2.
University
Right,
means
right.
Aligarh Muslim University.
I think I can assist the court.
Because, volume 3G, I'll tell you why I asked the question. Volume 3G, I have multiple windows open. Volume 3G at page 40, contains the amended definition of university. Where is the original definition of university? Which volume will we get it?
It's same volume, page 5, my lord.
Page 5.
But originally it just referred to the university. Now it's gone further. And this is struck down. My lord, I'm trying to go fast, my lord, because I need.
I just, page 78 of 4A, page 78.
Hurry. Anyway.
Right, I got it. So 2H original.
University will be Aligarh, left hand side.
78. So page 78, I'm obliged to my learned friend, my lord. It simply said on page, it said it on H, my lord, there was no L, I'm right.
But
It says in H, university means the Aligarh Muslim University. That's all. Is it clear now, my lord?
before the 1981 Act,
Yes.
you had I, J, K,
Up to H, my lord.
because the original Act has only up to H.
That's right.
Now, original H was obviously substituted sometime before 1981 by some other Act.
3H. 51, 65, 70.
Right, so we just want to see the whole unfolding,
I'm
how
going
it goes.
to, I'll be.
My lord, let them place it, my lord. That was there in Aziz Basha as well.
So,
But
in
there
any
is a
way,
time constraint.
the original definition of university said the Aligarh Muslim University.
That's right.
This amendment says established by, means the educational institutions of their choice, established by the Muslims of India, which originated as the MAO College Aligarh and which was subsequently incorporated as the.
This brings in the history.
So really speaking, what this tries to do is to take away the basis of Basha. Because Basha says it was not established. It was not established.
Absolutely right. And that is the issue, my lord, in the appeal.
The basis or not, that was the question.
Attempted to take.
Yes, attempted to.
Lord, whether Parliament has the right, whether it is an appeal or whether it is a brazen overruling, that, my lord, will have to be decided.
But therefore, for the purpose of this reference, we proceed on the basis that the amendment is valid? Because
No,
we
but-
can't do that because we are a larger bench.
To some extent, my lord,
Because Allahabad has struck it down.
that's right.
So we can't treat it as valid today, and there is an appeal pending before us.
Right.
Dr. Dhawan, your argument is on the first issue, is that Pasha, both the conclusions, as far as established,
This is not in the
Yes.
statute. It's been struck down.
Yes, ma'am.
established and administered is concerned is incorrect. So if you succeed on this ground, then the other point, whether the amendment is,
That's true.
By the seventh.
It will not survive.
it will not survive.
If Aziz Basha goes, it won't survive.
It won't survive. Because the issue would be whether these amendments made
This is that these amendments are.
deal with the reasoning part of the judgment and try and overrule the reasoning part of the judgment by legislative amendment, or they are in fact making changes in the statute itself.
So subsequent decisions of the court, my lord, and the statute. We are on now.
Yes, so subsequent decisions of the court, that's your
I've
argument.
dealt with it. I've dealt with it.
So therefore, you've taken this point at the end.
Yes, yes, of course.
And Dr. Dhawan, what happens is, this does not say notwithstanding any judgment, decree or order. It's not a validating provision. It's merely an amendment of the definition provision.
Not to say
What it
invalidating.
basically does is to introduce a new definition of the expression university
Correct.
to provide that this is a university which is established by the Muslims of India, originally called the the Anglo-Mohammedan Anglo-Oriental College, and which was subsequently incorporated.
Correct.
So the definition traces what in the view of Parliament is the evolution of the AMU, original establishment.
That's correct.
Then the Mohammedan Anglo-Oriental College, and then subsequent incorporation.
Correct.
This doesn't override Basha.
No, my lord, section 4 is what I
Because
thought.
Parliament could have taken away the basis of Basha. What it really does is merely to alter the definition, that's all.
No, my lord, kindly come to section 4, my lord. On page 148. Because it goes further and in.
Dr. Dhawan, just remember one thing. Today you're arguing a specific case, but what you are arguing may have its repercussion in other matters.
We do, my lord. We do.
Just remember that.
I'm before a constitution bench, my lord.
Yes. So there's a distinction between amending a statute to take away the basis of a judgment
Correct.
and amendment which deals with only the reasoning part, not really the statute itself,
Correct.
and then tries to overrule the judgment.
My lord, I have dealt with that in my submission.
Overrule the judgment in the inverted commas.
Correct. And Pavitra 2, my lord, now summarizes what this is. Your lordship's decision. Now, my lord, it's not just the preamble, my lord. It is amendment of section 5 because it's a substantive change. Subsection C to promote specially all the educational and cultural advancement of the Muslims in India. So it's not just, my lord, the statement of objects and reasons. Or the definition clause. This was also struck down. And that is important, my lord. Notwithstanding may not be there, my lord. Because your lordships have held from Prithvi Cotton, that's not a necessary provision.
Genuine.
some of the provisions and then come to the 82 Act. So lordships will permit me. Lord, 140,
Was it made with retrospective effect or was it prospective?
Lord, our argument was that since it's a declaratory statute, it will have retrospective effect. It's in my submission. It doesn't specifically say so, Lord, but it's a declaratory statute. Your lordship's judgments on this are quite clear. Can I quickly run through some of this, my lord, and come to the 82 Act? My lord, kindly come to 149 in this volume. With the proviso on 149 that nothing in this section shall be deemed to prevent religious instruction being given in the manner prescribed by the ordinance.
149 and,
Top of the page, it gives the section and puts in this proviso.
149.
Your lordship's decisions on the proviso are well known. Your lordship got it, my lord, in the top of the page? Volume 4A, 149. And this has not been struck down. I will. Can I quickly go through the act, my lord? The lordship will come to certain provisions.
Actually, Dr. Dhawan, the section 1(2) of the 1981 Act
Yes, sir.
is a prima facie indicator, at least. Section 1(2) is at least a prima facie indicator that it is prospective. Because it says it shall come into force with effect from such date as may be appointed in the Gazette.
Yes, of course, my lord. The act will come into
Now,
force.
we still take your point that in a given case, an act could be still
Correct.
declaratory of a position.
Correct.
Now, what we'll really have to see is this. When Parliament introduced the 1981 amendment, one aspect was the change in the definition of university. But did the substantive provisions of the amended statute make a fundamental change in the basis of the
Lord,
decision?
my respectful.
Because if it did not make any fundamental change in the basis of the statute which was interpreted in Basha, then clearly it's outside the power of Parliament to do so. Right? If Basha says, look, I'm relying on these statutory provisions to indicate that this is not administered by a minority, Parliament can then amend the statute, even with retrospective effect, to indicate, well, I'm altering these provisions to ensure that it is run by a minority. That Parliament can do. But if Parliament does not do that, if Parliament has not done it, it cannot merely by a change of definition overcome the impact of a binding judgment of our.
My respectful submission, if you see the change in 5C, it is a substantive change.
So let us see now which are those substantive changes that the 1981 Act brings about, and do those changes take away the basis of Basha?
That's right, Manoj. And therefore, it's not just the preamble
so 5C,
and the definition.
5C to promote especially the educational and cultural
advancement of the Muslims.
Then, Dr. Dhawan, if you say that it's a substantive change, then how do you say it's retrospective?
My lord, because of Aziz Bhasha being so limited,
No,
it is made clear.
that's a separate argument.
Yes.
That's a separate argument. That argument stands on its
Yeah.
own legs.
Correct.
It doesn't have to depend upon whether it's substantive or procedural.
That your lordships will decide. I can only,
But if you, once you say it's a substantive amendment, then it will, question of retrospectivity will be in
well,
different.
not my respectful submission is it changes the basis. It is not a brazen overruling as your lordship puts it.
I've not pointed out anything.
No,
It's just a question. It's just a question. It's not my opinion.
No, my lord, that is the whole purpose, my lord, of the Allahabad judgment. But that's a different matter, my lord. And therefore, my lord, on 149, the proviso is also a substantive change.
Of issues which will come up, but not confined to our.
Correct.
Lot of, on amendment of such a nature.
No, they will come up, my lord. But I'm merely placing it because your lordship wanted to know what the changes are. And the 81 amendment, my lord,
Actually, Dr. Dhawan, there are two separate issues. One, the first part of your argument has been that Basha is wrongly decided.
correct.
Basha is wrongly decided on the basis of the statute as it stood on the date Basha was decided. Okay, that's one aspect of the controversy. The second is that the basis of Basha is taken away by the subsequent parliamentary amendment, and which has been rejected by the Allahabad High Court. Allahabad High Court says you have merely nullified the effect of the judgment of the Supreme Court, which is not open to you.
Absolutely, my
That's
lord.
Parliament.
But that is the subject matter of appeal before your lordship.
But I'm only on this. Can we really separate out one from the other, perhaps? Because for our purposes,
Correct.
do we proceed on the assumption that the 1981 amendment is valid or invalid? We will have to treat it as invalid if we are not adjudicating upon it, because then we have to proceed on the basis of the law as it stands following the judgment of the Allahabad High Court.
That's right, my lord. Allahabad
We
High
treat
Court
it
says
as-
invalid.
Right.
I'm saying, my lord, that that decision is wrong.
You're right. So if we have to treat it as wrong,
Yes,
we can treat it as wrong provided we overcome or overrule Allahabad,
of course, my lord.
right? For the purpose of this reference, if
Yes.
we treat it as valid, we will be sub silentio saying that Allahabad High Court's decision is incorrect. In which case, if we send it back to a three-judge bench, what will that three-judge bench proceed on the basis of? They will say our seven-judge
Not-
bench is
If
proceed
your
on the basis
lordship
that the
says it's
amendment is valid.
invalid, then certainly it creates problems before the three-judge bench.
If we
At
say that it
present,
is
I'm
valid.
saying prima facie, this is what the 81 Act sought to do.
Let's read the act, nothing more than that, so that your lordship knows what the act does. And decide the question that has been referred to.
But Mr. Sibal, when we read the act, we will have to therefore excise those portions of the act which are not in existence by virtue of the Allahabad judgment.
That's not for adjudication in the reference, your lordship did not touch upon it, you answer the basic reference question, Madam.
We're not, your
This is
lordship,
only, since your lordship wanted to know what happened, Madam, this is only to show to your lordship. this is what
Mr. Sibal,
happened.
there is one problem.
we're not, your
which is that the
lordship should not
minority
uphold
character-
Allahabad in this reference.
No. The minority character of AMU, one of the considerations which we'll have to bear in mind is the statutory evolution of AMU, right? Now, in taking into account the statutory evolution of AMU, we have to look at the amendments which are made and the validity of any view taken by a high court striking down that amendment. That's a live issue for
For
us.
the purposes of this reference,
How do we ignore that?
My lord,
for
for
the,
the,
for the purposes of this reference, treat it as that, as a statute that's been, this void. For the purposes of this reference.
No.
You are,
No, but-
decide the question, the fundamental question, whether Aligarh Muslim University is a minority institution or not, that doesn't depend on statute, it depends on the
So-
judgments of this court.
No, but therefore, do we ignore the provision for your?
Yes.
Are you saying that we ignore section 2L as introduced by the 1981 Act?
81 amendment, ignore the 82 Act and decide the question, whether which is referred to.
my lord, at present, our respectful
Sorry for
submission.
interruption.
But then, one second, but then suppose when it goes to a bench of three, the bench comes to the conclusion that 2L is valid.
Will it decide?
Come back to 7.
One second, supposing your lordship comes to the conclusion, in fact, Pasha is bad. Nothing else has to come to the conclusion, Pasha is good law, then this question will arise.
Look, if we come to the first conclusion, then the amendments, even if they're struck down, may not make any difference.
Quite right.
Point I'm making. There is an academic.
May not make, but other,
If you hold.
but then Mr. Dhawan wants to argue that.
No. What I want to argue is, at this stage, your lordship will not preempt the 3-judge bench or the 5-judge bench.
My lord is.
That's all. Because if your lordship says invalid, that is the issue before the 3-judge bench or 5-judge bench.
This court.
Not before this.
For us to decide whether Basha is correct law or not, we have to look at the state of the statutory provisions as on the day before Basha was decided.
Yes,
The statute as it stood immediately before 1968.
that's the 20 Act as amended.
But look at it, how difficult it would be and inadvisable it will be to do that. That is, we decide upon the correctness of a constitution bench judgment, the constitution bench judgment in Basha on the basis of the statute as it stood in 1968. And that will have an impact on the minority status of AMU without us taking into account the subsequent developments which have taken place. Can we, in that sense, bifurcate
Not be ignoring. This is a remedial statute whose validity will be judged, my lord, later on. Don't preempt that process right now. Just say whether it's valid or not has to be decided by another bench.
If I'm not mistaken, this controversy also arose in relation to certain amendments under the Income Tax Act, ATM, if I'm not mistaken, or something like that. Because there was a judgment of this court, then the statute was amended. The judgment of this court itself was then referred to a larger bench.
Yes, yes.
Maybe section is wrong, but it was one of those chapter 6A deductions. And then the constitutional bench dealt with the main issue itself, relegating the issue whether the amendments made were correct or can withstand the constitutional violations challenge.
Yes. My lord, there are at least 45 decisions of this court going into this question, including tax, including labor, etc. And they culminate in Pavitra 2. I'm not, my lord, canvassing this here, but I'm just saying whether it's valid or invalid, your lordship will say will be decided.
We are not going
So
to that.
invalidate it
We are
at this
answering
stage is not correct.
We are answering a reference, not the appeal.
Correct, that's all. that our position is, your lordship should say the 81 lakh validity of these sections will be decided by that bench. The more important part of this amendment is on the administrative provision.
Because may I?
That's important, my lord,
May I intervene?
because that's the question your lordship put to me on administrative. So I'll just do that, Mr. Dwivedi, you can hold till reply.
No, I just wanted to say this, that the whole reference is arising in the backdrop of a challenge to the Allahabad High Court judgment, which has struck down this. That's the basis of the reference, and it comes to your lordships in that.
Trivedi, there's an issue on that. In fact, I was a little surprised by this plea raised by Dr. Dhawan. His primary argument is the reasoning given. Forget about he's saying accept the statute as it existed. The reasoning given to hold that the university is established and administered not by the minority community is wrong. So he's challenging that, and he relies upon one. Just one. He relies upon two arguments. The basis of the judgment itself is flawed internally, and in terms of the law as laid down by this court, starting from Kerala, right till the end, TMA Pi, etc. He's not referred to the subsequent judgments after TMA Pi, but that
With respect, Lord.
Now the second aspect is, if we accept that argument of his, there's no difficulty then. But if we reject his argument, then the constitutional validity of the vires of the 81 amendment arise for consideration. 81 amendment per se has not been referred to, this appeal has not been referred to be decided by this bench.
No, that's the basis of the reference, Lord. If you take it away, then it becomes the review petition against.
81 order of Justice Fazal
Not a review
had
petition.
nothing to do with the amendment.
Lord, I'm sorry, my lord, 81 order of Justice Fazal Ali does not pertain to Allahabad Muslim University.
Correct.
It was some different institute.
Correct.
Thereafter, my lord, when the challenge to the
My lord,
Allahabad
let
High
us
Court.
finish.
But there's a point.
Let us finish.
There's a larger point, Lord. The
Lord,
question is when the law.
Coming to the larger point.
No,
No,
My lord,
the-
the 1981, my lord, this is not fair.
No, it's
This
not-
is not fair. I'm at the fag end of my argument. They have the right to reply.
My lord, at
No,
the
we are on-
outset-
My lord, whether it comes in the reference or not, your lordship will decide. So this is not fair, my lord.
my lord,
This
at the
popping up, my lord, I've rarely seen in this
So
court.
we can also raise voice, Mr. Dhawan.
No, my lord, it's not a question of raising.
No, Dr. Dhawan, yes.
Let me proceed, my lord.
Only one
All
thing.
right,
Let
one
me
second.
proceed
one thing,
on
my
the
lord.
81 amendment, my lord. The 81 amendment has two parts. One part relates to Aziz Basha and those changes. The other part, my lord, which is the more important part, relates to administration, which is not struck down. And I'm putting it before your lordship because I have to. But your lordship's question is, what about the administrative parts? I quickly run through them, my lord, when I want to sit down.
Yes,
So, my lord, kindly come to page 149.
149, volume 3A.
No.
Oh, sorry, we are at
4A.
volume 4A.
Yes.
Now, my lord, at 149, we begin on the administrative parts. And that is your lordship's question. I couldn't say, my lord, on the change in basis, I had to put it to your lordships. Now, my lord, kindly come to 149, subsection 7. Chancellor shall be elected by the court. One amendment to section 18, pro-chancellor shall be elected by the court. 20A shall be elected by the court. Then, my lord, section 23 is important. Because over the page, my lord, at page 140, subclause 2, 150, The court shall be the supreme governing body.
Drastic change.
Different from 1920, it's supreme body.
Yes.
Not the Muslim.
My Lord, I love the choir, my Lord, but I don't have to deal with it. So, my Lord, if your Lordships were to see all this, and that is the important thing, that the administration, my Lord, makes it absolutely clear, will be under the supreme body. That is the question your Lordship put to me. That question of changing the basis, my Lord, will be decided later.
Inconvenience will be decided.
The basis of the judgment.
And de facto, my Lord, I've shown to your Lordships that de facto they are all part Muslims. That's how the Union of India sees it when these appointments are made. In my written submission, my Lord, it's at para 67, page 67. The de facto argument is also there, my Lord, because you all gather it to see who is actually administering. Now, my Lord, may I come to the 82 Act very quickly. 81 Act, page.
This was the 81 Act.
We've dealt with the amendment, now we look at the Act.
Yeah.
Because all those provisions about Islamic, promoting, all those are there.
Let's see those now.
I won't refer to that because everything else remains the same.
Where is that Act? Where do we get that Act?
3G. That is at page 38, my Lord. Is it? Yeah. So, my Lord, the amendments are there, 2L, etc. is there. I don't want to go into that. But the substantive amendment, my Lord, on page 41, section 5, subclause C, is not definition, my Lord. It's a substantive amendment.
Section?
My Lord, 41, the change in C, which has been struck down, but that's a different matter altogether.
5C.
But if you see 52A, which has not been struck down, to promote Oriental and Islamic studies and give instructions in Muslim theology. This has not been struck down. It remains. Yeah, the original 52. So, my Lord, that has not been struck down. Then, my Lord, page 42, if your Lordship will permit me.
Yes.
May I proceed, my Lord? Your Lordships will see 9A. Amended in 72, which is original section 12, my Lord, goes into this, to establish within a radius of 25 kilometers of the university mosque such special centers and laboratories for research and instruction as are in the opinion necessary. So it has this other aspect, and your Lordship stay order, your Lordship indicated that this will continue. Then, my Lord, I come to very important provisions. Kindly come, my Lord. All that business about the college is transformed, I won't go into that. Kindly come to page 45. The rector disappears. He becomes the visitor. So, my Lord, as far as the visitor is concerned, we know, as I indicated, there is a template. the external bodies and the internal bodies. So the visitor, my lord, will say, are you administering it properly or not? And that concept of visitor, my lord, is there in all the institutions. Your lordship as chancellor has that power. Whether it's Bangalore, Calcutta, whatever it may be. This is not an invidious provision. Then, my lord, if your lordships will come to 47, chancellor now is elected by the court. Section 17. Pro-chancellor is elected by the court. All those colonial provisions are gone. 19, my lord, vice-chancellor shall appoint the visitor, and the recommendation, my lord, will come from the court. That's on page 61. 62. Then, my lord, kindly come to 23 as it stands now. I'm on administration. The court shall consist of the chancellor, pro-chancellor, vice-chancellor, etc. It shall be in subsection 2, the supreme governing body. Then, my lord, page 53.
23 is powers to elevate. 22.
Yes, just one second. Dr. Dhawan, the composition of the court,
Yes, sir.
which becomes the supreme governing body of the institution, is provided in this particular statute itself, right?
Yes, sir. And it will be there in the statutes as well.
81.
Can we just see where these statutes are?
I will, my lord. My lord, I just want to.
Because section 23 says, the court shall consist of the chancellor, the pro-chancellor, the vice-chancellor, the pro-vice-chancellor, and such other persons as are specified in the statutes. Now, who are those such other persons which the statute specifies?
I'll show that.
Right.
I'll show that. Just note 53, my lord, on the ordinances, giving of religious instruction in subsection J, which was there in the original act. Now, my lord, I'll take your lordship straight away to the statutes. My lord, I'm not going to cover the ground that I did in 1920, that the religious aspects are there, my lord, because that has not been changed. Now, my lord, kindly come to the statutes.
Page starts at page
60.
60.
Yeah, it starts at 60. The relevant provisions, my lord, are on page 74.
'74.
70. Can I take your lordships to some of the provisions now?
Yeah.
Because your lordship asked what the others are, my lord. It, my lord, as the usual provisions, the staff must be there, the students must be there. Then, my lord, on 75, the donors. Of course, they may not be Muslims, but the point is most of them are. At the bottom of 75. And then, my lord, ex-students are there. Page 75. Just at the bottom of that page. Now, the important provisions, my lord, which I pointed out in the 1970 Act are still there. Page 76 is important in this respect. Can I proceed now? 76 says, my lord, remains the same. Representatives of the All India Muslim Education Conference. Then, my lord, representation of Muslim culture and learning. Now, my lord, kindly see on Muslim culture and learning, 15 persons representing Muslim culture, 6 persons representing Muslim colleges of Oriental learning, 4 persons from Waqf boards, 2 persons representing Urdu language, 5 persons representing Muslim educational and cultural societies situated outside the state.
As I made a mathematical total, this clause 15 to clause 29,
Yes.
sorry, clause 25 to clause 29 it would include 15 and 6, 21, and for 25, 27, and 5, 32 people. Now, what is the total composition of the court in terms of numerical strength?
Plus 5.
About 180.
180. So in 32 out of
overwhelming majority throughout the existence of the de facto has always been Muslim, although it may not be specifically stated that 90% which test of de jure and de facto. I don't know that.
that's a legal argument, but as a matter of fact, in the court, now we are clear that court under section 23 is the supreme body. It performs all the executive functions. It is a governing body. Now, expressly by the statute, there is a requirement that 32 people out of the 180 odd must be, ordinarily there would be Muslims. I mean, there are 5 representatives.
These are Muslim institutions.
Yes, of course.
Their
5
representation.
representatives of the All India Muslim Education Conference. Then that's right. So it will be 37. 37 out of a total of 180. Would that impact upon whether we call it?
What?
Because it's the words are established and administered by.
Lord, what I put to your lordships, Lord, as in Faiz-e-Aam, now, my Lord, liberal education requires all these representatives. Therefore, the important point is the presence, my Lord, not just Muslims, of these institutions is enough, my Lord. Whether it should be majority or not is another matter.
But if we say that, the test under Article 30 is that it has to be administered.
Yes.
Would it be sufficient that the administration is given to a composite body, a large body, a multi-member body, out of which, say in this case, 32 or 37 out of 180 are Muslims? What does that then satisfy the administration test under Article 30?
Our respectful submission is the presence is there. And that is enough. In this day and age, my Lord, you have to incorporate the other people. As your Lordship put it, the students are there, the staff is there. It's inevitable, my Lord. But that doesn't mean the hold in one sense or the presence has been affected in any way. It doesn't have to be 100%.
Dr. Dhawan, what is worrying is this. The test is of management, right? For the purpose of administration. Now, we take your point that, well, as a university now governed by a law, you have to induct people who are representatives of various stakeholders in the university, the teachers, the students, the faculty, so on and so forth. We got that point. But then this would really lead to a de minimis argument that, look, even though the controlling voice in the administration is not that of the minority, yet we must still treat it as being administered by that minority. For treating an educational institution as administered by a minority, should the controlling voice in the administration not be of the minority?
It is not.
Or even if Or could it be? I mean, we are formulating the hypothesis. It's an important issue to consider. Could it be the law, or could it be the position in constitutional law that even though the controlling voice in the administration is not of the minority, yet it should be treated as a minority educational institution under Article 30 because the minority has some element of presence in the managing body. Will some element of presence in the managing body suffice?
My Lord, our respectful submission is that take the vice chancellors, my Lord. They've all been Muslims, they will be here as well. Then the de facto argument, my Lord, is an important argument. And therefore, my Lord, presence, they haven't lost control entirely to secular forces.
All vice chancellors have traditionally been elected by the court, right?
Yes, all of them,
They are
barring
not
three, my
appointed
Lord.
either by them. And therefore, Shatan's argument that look
Yes.
at the de facto and not just the de jure.
So, my Lord, your Lordships will examine the de facto argument and the de jure argument. And combined with that, this presence is enough. Where do you get in other statutes a presence like this? I'll leave it there. Now, my Lord, all the other provisions of an Islamic nature, my Lord, I don't want to go through them. That's the same as the 20 Act.
Is your argument? Is there any
Now, what I want to say, my lord, if your lordship looks de facto, it is administered by Muslims. And your lordship will examine that. Basha was concerned only with establishment.
Perhaps that Mr. Farasat will take on that particular link, or Mr. Sybil will take on that link. We will see who's going to that, yeah.
And then it
So
says,
you said
even
that
if
de
you're
facto-
administered, it is irrelevant.
Possibly.
Now, my lord, my written submission, my lord, I'll just take 2 minutes.
Volume?
Volume 1A. Now, my lord, as your lordship got it, page 9. These are the issues, my lord, that this written submission deals with. Your lordship will examine them, my lord. I've dealt with all these. Also, my lord, your lordships will see this business of the 81 Act, my lord.
In fact, Dr. Dhawan, first two questions are the real ones. Right?
Yes.
Probably,
Naturally, because Aziz Basha is quoted in the reference.
first two and 5.
Yes. 4, my lord, also arises out of the reference. 5 arises out of the reference.
4 will arise in a slightly different way, not directly.
No, my lord, because
directly.
the reference refers to the UGC and the National Minorities Act.
Okay.
So it's taken
Okay,
from
fine.
there.
Okay, fine. That will be their argument, in fact.
Now, my lord, all this business of the Allahabad High Court, my lord, is at page 44.
5 and 6 will.
I don't want to go there, my lord. Your lordship's question is on administration. So the two parts of the 81 Act can be delineated. That dealing with changing the basis, and that dealing, my lord, with the administration. There are two distinct parts to the Act. I have put in the argument on changing the basis. Your lordship need not decide it right now. That is for another bench, my lord. I'll just take 1 minute. Hello, that's me. I think you want to hear another voice. I'm sorry I've stepped over, my lord. Your lordships are conferring, rightly so.
Anything else, Mr.
That's all.
Doctor? Thank you very much, Doctor. We'll hear Mr. Sybil after lunch. Thank you, Doctor. Yes, Mr. Speaker.
If I may, my lords, brush the canvas, my lords, with a broad brush to tell your lordships why and how your lordships should look at this matter. Well, this is, first of all, a pre-constitutional law. The 1920 Act is a pre-constitutional law. Pre-constitutional laws have to be tested under Article 13. If they are inconsistent with any fundamental right, they can be struck down. Article 30 is a right, fundamental right given to minorities. If your lordships looks at the 1920 Act, I'll come to that later, and comes to the conclusion that the Act itself is ultra vires Article 30, your lordship can strike it.
But has there been a challenge to the validity of the Act itself?
No, the Act says it can be altered also under 372. The Act itself can be
in the
altered.
proceedings before the...
No, today, Manoj, today your lordships are testing the validity of 1920.
But no, where is that? Is there a challenge to the validity of the Act?
When Basha is already, I'll come to that. Manoj, just let me. When Basha itself is the subject matter of reference, then you'll have to decide whether Basha is rightly decided or wrongly decided. That will, in turn, lead your lordships to testing the 1920
But if you strike down the 20 Act, then the very status of the university evaporates.
No, Manoj. Strike down the 20 Act in the context of Article 30. That it violates my right under 30. And that takes your lordships to the reference of Basha.
Sybil, what's your argument?
Well, my argument is, please look at it as a pre-Constitution Act.
Correct.
And in the light of that, test that Act in the context of our constitutional right under Article 30. You may come to the conclusion that the tests laid down in terms of Article 30, because Malas, the Basha judgment came in 1968. No, Malas, much water has flown down the Ganges after 1968.
But nobody
By-
challenged the Act, Mr.
Malas,
Subbat.
I'm not
How can we
staying.
deal with the validity of the Act?
Malas,
in a vacuum?
please, I am just at the moment, Malas, only asking your lordships to look at it as a pre-constitutional law. We'll come to the argument as to how it can be challenged, how it can't be
Now,
challenged.
all of you are appearing for Aligarh Muslim
I am
University.
appearing, Malas, for the Old Boys Association.
Old boys. And Mr.
He is
Dr.
appearing
Dhawan was
for the
for
university.
AMU.
Yes.
And Chadan?
Right, Malas.
But no
No.
challenge to the Act. How can we...
No, I'm not, Malas, I'm not challenging the Act at all. Please appreciate, Malas. I'll asking your lordship to interpret the Act in terms of Article 30.
That's of course...
That's all that I'm wanting your
There's
lordship
no
to do.
difficulty there.
Yes,
that we can
that's all.
always...
In violation of my right under 30, there's nothing more than that, Malas, that I'm asking your lordships to do.
Yeah.
Now, Malas, as your lordship knows, Malas, Article 30 has been interpreted over a period of time. And when Basha came into being in 1968, Malas, there are several judgments after Basha, which give your lordships as to what the true meaning of Article 30 is. Right, Malas? Those judicial dicta will have to be taken into account to interpret whether Basha was rightly decided or wrongly decided. Forget, Malas, the amendments made. I'm not concerned with that.
2861. We are putting 28.
Now, Malas, if your lordship looks at the Constitution in the broadest sense, Malas, what happens is, Malas, there are all kinds of minorities. There are Hindu minorities, there are Muslim minorities. But when it comes to Christian minorities, when it came to, Malas, scheduled castes and scheduled tribes, a special, I'm talking about now education, a special provision for reservation for them was made, Malas, in the Constitution itself. Then came the amendment to Article 15, Malas, and that reservation then was extended to the backward community. So you have reservations in educational institutions for scheduled castes, for scheduled tribes, for backward communities. no reservation could have been given to the Muslim community or to the Christian community or to the Sikh community because it would be violative of 15 and 14 and 16. So in the context of the framework of the Constitution, there was no other way to give an opportunity to those left out
No, Mr.
to allow for education.
No, Mr. Sibal, I don't think the reference is on this issue.
I'm
We are
not,
look, Article 30 has its various connotations. There is impact of Article 30, which is entirely different from what we are deciding today. We are deciding only a limited question, what is meant by the term established
agree.
and administered in Article 30. We are not dealing with what is the effect if an institution is declared to be a minority institution. Because that's been
I agree.
subject matter of a lot of debate. Probably they wanting us to go into that. But
Manoj,
I'm also wanting
I'm
us
giving
to
only
go
a background, Manoj. This is not, please
Are
appreciate
you
this.
wanting us to go into that question?
No, I'm just giving a background as to why 30 came into being,
What
Manoj.
you're saying is that the beneficial provisions which were carved out for, say, these SCs, STs, and the socially and educationally backward classes could not have been given to the minorities because they would have been the bar of 15(1).
That's right. And
no discrimination on grounds of
that's,
religion.
there is a
So
rationale.
therefore, what was the special provision which was crafted by the constitution makers? Article 30.
That's right.
That's why Article 30 has been called, in a sense, an article of faith.
That's correct.
We must put ourselves back in 1949, 1950.
Exactly.
And the idea was to give a sense of confidence to the religious and linguistic minorities.
That's right.
That they would be safe within the confines.
It is in this context that Article 30 is in the Constitution. I'm just giving your lordships just the broad constitutional framework. So when this happened, Mullahs, look back at the time of 1950 when we became a republic, Mullahs, where were these higher educational institutions? There were none. In fact, Mullahs, the only 5 or 6 higher educational institutions were University of Calcutta, University of Allahabad, University of Lahore, University of Bombay. And University of Calcutta and Madras. That's all.
In fact, Mr. Sibal, Bombay University had jurisdiction over present-day Karnataka,
Yes,
Maharashtra,
yes,
Gujarat, and if I'm not mistaken, parts of Sindh as well.
correct. But therefore, Mullahs, there were hardly any institutions of higher education. And Mullahs, if your lordships are aware, and I'm sure your lordships are, only 14% of India was educated. 14% of 300 million people. There were no institutions. So when these 5 institutions, Mullahs, actually, they were set up after 1857. And Mullahs, it was set up on the basis of the London University. Because unless you had a university, Mullahs, you couldn't get a job unless you had a degree. So when these universities were set up, Mullahs, then the British thought that we must regulate them also because they must have standards. This is all as a background to look at 30 later, Mullahs. I'm just giving your lordship some background, nothing more than that. So Mullahs, in 1904, a regulation was framed that all these universities must be regulated under one statute so that standards are maintained. Right? No, it's okay. Then what happened was, Mullahs, in the meantime, there was this movement by the minorities and by the Hindu community. And what about our institution for us? So the genesis of Aligarh Muslim University is based on this movement within the minority community that apart from these 5, 6 universities, we must have a university for ourselves. That's how the Aligarh Muslim University came into being. And imagine, Mullahs, Sir Sayyid, and I'm talking about 1870, Mullahs, the patience that that man had. That we should not be looking at Muslim education alone, we should be looking at secular scientific education. English language should be And the kind of subjects, Malad, that were to be taught, I'll show your lordships. The same Malad's movement was in the Hindu community. So Malad's, around the same time, Malad's, the Banaras Hindu University was set up and the Aligarh Muslim University was set up. So what happened was, Malad's, when the Republic came into being, these were the two universities, one where the minority, the other where the majority, Malad's, they became institutions of national importance. Why? Because they were set up, Malad's, under the Central Legislative Assembly by an act of the Assembly itself, of the central government, the British government, of the imperial government.
So what were the other universities, which were?
By acts, Malad's, by
They were all of
separate
them are
act.
by act.
Yes. And then they're regulated in 1904 together.
They were
It
regulated.
will have an impact on the meaning of, why am I saying this? It will tell you the meaning of established. It will give you a meaning of administration. Give you some indication as to what it means. Then, Malas, what happened was, then these were the only two universities, Malas, which were set up by the Central Legislative Assembly. And your lordship knows, Malas, the time when the Constitution was framed, education was a state subject. So they could not be administered by the state in which they were located. Both were in UP.
In fact, apropos what your submissions, sorry for the digression, if you look at entry 63
I
of
was
this
coming
one,
precisely to that.
union list, it
Yes.
says the institutions known
Of
at
national
the
importance.
of the commencement of this constitution as the Banaras Hindu University,
Yes.
the Aligarh Muslim
And
University,
the Delhi University.
and Delhi University, the university, and then it came later, the university establishment pursuant of Article 371E. Any other institution declared by Parliament
Yes.
by law to be an institution of national importance.
Yes. And Malas, Ambedkar says this is because we must protect the cultural ethos of India. The genesis is a movement, Malas, within the Muslim community that we must have an institution for ourselves. Now, Malas, there is, if your lordships ask me, there is an actual confusion as to when a statute recognizes a university degree, it establishes the institution. Malas, there's a complete confusion. It has nothing to do with establishment. A degree granted by a university is a recognition of that degree, which allows you employment. Nothing more. The concept of establishment is dehorsed that. It's an act of recognition by the state of the degree.
But the Anglo-Mohammedan College could have well been affiliated to an existing university.
Yes.
In which case they couldn't have granted their own degrees.
No.
They could have been affiliated.
Correct. And
to
that's only a recognition of the degree that you, whatever course, like St. Stephen's, Malas, is affiliated to Delhi
University.
So you get recognized the
But
degree.
they constituted a university.
Yes.
So that they could themselves grant degrees.
That's correct. And that's for what? Recognition of their course of studies consistent with the standards set up by the government. That's the heart.
What is the year of the setting up of Banaras Hindu University? Because
Same year, but
it's also
16
celebrated its 100 years.
1915.
1915.
1915. So
Yeah.
2015.
And
they
this college was affiliated with Allahabad University.
That's correct.
And Allahabad University used to confer degrees.
That's correct.
This MAO.
Oh, I see.
So there's
Calcutta, then
First Calcutta University.
Calcutta and then Allahabad.
Then Allahabad University.
Yes. Therefore, there's a basic, according to me, quote unquote, confusion that the grant of the status or recognition of a degree is the establishment of the institution. Well, today, for example, I set up a minority institution. It's recognized as a minority institution. And I set it up. Will I lose my status under the present law?
Which are the, just as a matter of interest, which are the minority universities in the country today?
Many state universities. Now, after Basha, what has happened is, the states allow a minority institute. What happens is, I want to set up a minority institute, say a Sikh institution or a Christian institution. I set it up.
You have the Christian Medical College, Vellore, for instance.
Well, that's
I'm
an
not
old
sure whether
one.
it's a
That's
deemed-
an old institution, but I set it up now. Supposing tomorrow I want to set it up after Basha. Once I set it up, I go to the National Commission for Minority Education. And I apply to them and saying I set it up as a minority institution. They will ask me for several facts as to what is the reason, why have you set it up, where's the funding, are you financially capable, this, that, and the other. And then they will grant me the status of a minority.
But you don't get the status of a university under the Act.
No, you do,
No,
you
no,
do,
correct.
you do, you do.
But before 2010,
Before 2010 also?
because the act is of 2010, the National Commission.
No, it doesn't matter. Before that also, you do. There are several universities.
No, but they must have applied after the 2010.
That's right. And deemed universities also.
And
And then the third most important point, I'm just broadly telling you a lot. The third most important point, when Basha was decided, the UGC Act was enforced. The 1956 Act, the NCMEI was not enforced, but the UGC Act was enforced. Now, under Section 23 of the UGC Act, nobody can give a degree unless it is through the UGC Act. You can't give a degree. You can't call yourself a university. You're either a deemed to be university or you're a university. Or you can't use the name. So how do I become a university? I mean, it's a contradiction in terms. I set up a minority institution, a minority university, which I'm entitled to, and I'll come to that in a minute. And then the moment I'm registered as a minority institution and I get university status, I become a non-minority institution.
the right to set up probably is now, after TMA Pi, closed from 19(1)G as well as 26.
That's the main, I was coming to that, that's the other scheme that I was coming to. Why did TMAPI decide what it decided, and why did it leave that question open, which was actually referred to it? I tell your lordships why. I argued in TMAPI, having opened the argument that, look, both the majority community and the minority community are entitled to set up educational institutions, according to me, of their choice. There's no bar. Court asked me under which provision. I said 19(1)G. 19(1)G talks about occupation. Setting up a university is an occupation. So the majority community can set it up, the minority community can set it up. Both under 19(1)F. But the minority community has something more than 19(1)F. 19(1)G, which is Article 30. Now read Article 30 with me. You don't have to read it, Mullahs. All minorities are entitled to set up educational, whether based on religion or language, can set up institutions of their choice. Right? The choice relates to what? School, college, university. Choice can't be limited under Article 30. I can set up a school, I can set up a college, I can set up a university. Now you say I have a right to set up a university, but if I go to the statute, if I go and get myself, go to the UGC and say I'm a university, then I lose my status. It's ununderstandable. The very logic is ununderstandable.
What was the question where the universities had already been set up before 1956 and were already giving degrees. What is the position under the UGC Act?
Well, they were not minorities. We were only.
Forget about minorities.
Yes. Yes, they were giving degrees, Manoj, and I tell you, Lodge is there.
Those degrees continued to be recognized and
Yes,
accepted under.
yes.
So in your case, you were giving degrees even prior to that.
No.
You were giving degrees after 1920.
After 1920, yes.
So the UGC Act, therefore, to that extent, did it prohibit you from giving the degrees?
No.
So you are independently
Yes.
incorporated.
Till Basha came, Manoj. Till Basha came. This Basha came, Manoj. It's a very strange situation.
No, even after Basha.
And after 1982 Act also, we were continuing to be a minority institution. Then also, nobody challenged that act. I'll tell you, Lordship, how it came about. But I'm not into the 19... See, basically, Basha says that, look, you could have set up a university and could have given degrees. Well, how could I?
Actually, even after Basha, degrees are given and can be given.
I am on...
Yes.
I request my learned friend.
No, therefore.
It doesn't matter. Every incorrect statement I make need not be corrected by you. Because every incorrect statement you make, I never correct.
Incorrect statements are very potent.
Incorrect statement you make, I never correct. Because I believe you will always make correct statements. So, Manoj, what is the point that I am making? That you can't lose your status as a minority institution the moment the UGC grants you the status of a university. When Article 30 entitles you to set up a university. You can't say now Article 30 doesn't entitle you. So Siddhaj Bhai, when it says, Manoj, and this is really the other confusion. Siddhaj Bhai, when it says that Article 30 is an absolute right, is absolutely right when it says that. That absolute right is reference to the choice. That absolute right is not with reference to regulation. Which is why TMA Pi later says, you will be regulated. You can't say that you will not keep your sanitary standards. You can't say that you will not keep this standard, that standard. That comes from where? From 1906. So every university, whether a minority university, will be regulated in public interest under 1906. Right? But it has the right to set it up under 30. Regulation is nothing to do with the establishment. Regulation is to ensure that you keep the standards of education, excellence of education. And without any doubt, Aligarh Muslim University is, the other day I was in Riyadh, giving a lecture. Almost all the doctors are from Aligarh Muslim University serving the royalty there. I was in Doha. All the chartered accountants from Aligarh Muslim University are chartered accountants, are all Muslim. Of course, many of them said, we can't get a job in India. We were forced to come out. We love our country. We'd love to come back. And Manoj, I want to ask myself a question, Manoj, and to you too. What is the right that a minority has today? What is the right? I have to comply with all standards. I can't appoint a teacher without an appropriate qualification. All universities are entitled to appoint teachers of that qualification. Majority has that right, minority has that right. I must comply with the student-teacher ratio. My courses of study must be consistent with the university courses of study, otherwise I won't get recognition. What is it that this article gives me? Just a bit of reservation, no? Or is there anything else? Institution that I have established, I just want a little reservation. You want to deny that also? There's nothing else, there's nothing else. Now, if, Malaj, there is undue interference, undue interference in the function of my university, then it is my right to challenge it and say, you can't do it. But the administration of the university need not be in minority hands. I have the right to administer. I may say, you do it for me. It is my choice. But if you unduly interfere in my administration, I under 30 will challenge it and say, you can't do it. If it's 180 members and they are tomorrow interfering and they are packed with people, Malats, who are not in the I will challenge it then. It's not the other way around. Administration by outsiders doesn't destroy the minority character of my university. I can challenge it. That's not the test of Article 30. So if you look at it historically, I have nothing else. I don't have reservation. Very few people in the community are, and well, let's be clear on it. And these are factual matters, which it is a matter of public discourse, Malas. I mean, we are under scheduled caste, Malas. We are even below them in terms of education. So we are not empowered enough. The only way to empower our children is through education. And in higher education. May I just tell your lordships, in all these courses, in Aligarh Muslim University, like MD courses, MS courses, engineering courses, the minority students are not around. Most of them are majority. Why? Because they have not been empowered from school. The only places where they are in majority is theology, religion, because the majority community doesn't want to be part of that. So one, we are not empowered. Two, we want to be empowered. The only way to empower ourselves is to allow us these universities. Give us that right. Give us the right to be called a university. Allow the Muslim community students to get a higher degree. Let them get jobs. And you say, no, this is not minority. Why? Because you have been recognized by statute. That's Basha, Balas. So then the question that arises is, if the grant of the status or recognition of a degree is not the indicia of establishment, what is the indicia of establishment? Then you come to that question. And when the Central Legislative Council, when this university was set up at that time, there were certain debates that took place. Would my lords be kind enough to turn to that? Volume 4, 4C. PDF 40. And remember, Malas, I'm sorry, my mistake. I have the choice to establish, I have the choice to administer.
No, if you don't have the choice to establish or the choice to administer, it says all minorities, whether religious or linguistic, will be entitled to establish and administer educational institutions of their choice.
Yes,
Of their choice qualifies educational institutions.
yes,
So you can set up and administer educational institutions of your choice.
yes,
Now, once the choice in setting up the educational institution is recognized, once the choice where the education institution is recognized,
yes,
the choice is yours as a
Yeah.
minority. You have to establish it yourself if you have to get the benefit of Article 30.
yes.
If someone else wants to administer your institution, you can challenge that provision.
That's what I'm saying, Manoj.
But to the extent to which you want to cede the right of administration to others, is your choice again.
Again, my choice. That's what I said.
That's what your argument is, that you are not compelled
Yes.
at the cost of your minority status to be required to administer it 100% yourself.
That's right. Manoj, therefore, Manoj, I can establish an institution of my choice and I can administer to the extent that I want. It's my choice. It's as simple as that, Manoj, in very simple terms. Why, Manoj? Because what your lordships have held, right from Manoj Aarti Kerala, right to TMI, that the government cannot interfere in your administration to the extent that it whittles down or destroys the right under 30. Therefore, it's the non-interference which is protected by virtue of the fact that I'm granted the right to administer. I hope I made myself clear. I have the right to administer, Manoj. Now, that right is mine. If you say, for example, now...
But can you say, Mr. Sibal, that I have a right, I have a choice to establish?
Yes.
Instead of establishing it myself, I will delegate the power to establish to someone else.
No.
You can't do that.
No,
right?
of course I can't do that, Manoj. I can't.
You have to establish it yourself.
That's right. And I am right to administer it also. But if supposing government says, look, in your select committee, we will have a nominee of the UGC.
You can challenge that.
I can challenge that, but I can also accept it. Oh, it doesn't matter. I can also accept it. Now, if I accept it, doesn't mean that I've given up my right for it, that I'm not administering it. That's how, ultimately, Maharaj, everything else is controlled. There's nothing left, Maharaj. So what is given to the majority community under 19G, right, is regulated. What is given to the minority community is also regulated. And it's regulated under the same statute. So there's no difference. I don't get a higher right, they don't get any superior right. So what is the right under 30 that is left? What is left is just some reservation. Why? Because my community is not educated enough. Now they say, no. You are an institution of national importance, so you've lost that right. Well, it would be bizarre. I mean, you will destroy the very conscience of Article 30, Malaz, the very leitmotif of that article. Then you might as well get rid of 30. Then why have 30 at all?
The only thing which we'll have to consider is this, that at the birth of the Constitution itself, we're now not looking into, the broader aspects of the right of a minority to establish and administer. At the birth of the Constitution, Aligarh Muslim University was referred to EO nominee. There are only two institutions which are referred to EO nominee.
Yes.
Banaras Hindu University and Aligarh Muslim University. Once these are recognized EO nominee in entry 63 of list 1 and placed at par with institutions of national importance, as it calls.
Fair enough. We get some funding, Madhur, that's all. We got some extra funding. Please, you point out what is that everything. You're already trying to take everything from us. What do we get? Some extra funding as institutions of national. What of the IITs are all institutions of national importance under 64. What do they get, Malaz? The funding. Malaz, let's go back a little. If you look at the development of education in India as opposed to other parts of the world, Malaz, take, for example, Stanford. Stanford was set up by a magnate, Malaz, who used to run locomotives. He made billions of dollars, Malaz. And his son died, so he set up Stanford University. There was no regulation of Stanford University. It grew, Malaz, started awarding degrees. Yale was set up by Puritans. 500 Puritans, Malaz, who were anti-Anglican. The Anglican Church, Malaz, came and set up the university, gave its own degree. Harvard was set up by 1,700 Puritans. Cambridge, Malaz, how was Cambridge set up, Malaz? What happened was at Oxford, two people were convicted, which the Cambridge scholars thought were innocent. And the king supported that, their conviction and their death sentence. They were hanged. So, Malaz, the scholars, about 60, 70 scholars ran to Cambridge and set up Cambridge University, gave their own degrees. We are regulated. We are regulated. Why? Because we don't have the wherewithal to set up a university. The minorities, the Dalits, the scheduled castes, the scheduled tribes, the backward, very few of them have the capacity to set up a university. We're a poor nation, Malaz. Today, our per capita income is $2,000 per person, which is what? 230 rupees per month. That's a per capita. 800 million people are earning 5,000 rupees a month. Where are you going to get universities? And whatever little we have, we want to take that away also. Let's look at the context in which all this is being done. So it's all niceties of law are fine, Malaz, but what's the heart of the matter? Heart of the matter is the only thing we get is a bit of legislation. You want to take that away also. By some strange logic, sophistry. Now just see, Malaz, kindly come to volume 4A for a minute. Page 203. Now, this is the UGC Act, which was there in 1956. So, Basha was decided when UGC Act was in force. Now, kindly see, Malaz, the definition 2F university means. At page 203, my lords have that?
Mr. Sibal, after examining 2F read with 22.1.
23.
22.1.
Yes.
Of UGC.
Yes.
Then probably you have to answer.
Yes.
Your problem is created because of Pasha or because of these provisions under the UGC Act?
Basha decides the
Just
issue.
examine and just,
All right.
maybe that you have to respond to.
The lordships are asking me the question whether our problem is because of Basha or because of this act.
This Act.
Yes.
2F read with 22.1.
All right. Let me. Where is 22?
And see the
214.
and see the opening statement of the Act. It is referable to entry 63 of list 1.
Correct. That's right, man. 214. 22.1 is the right of conferring or granting shall be exercised only by a university established and incorporated under the Central Act, a Provincial Act, or a State Act, or an institution deemed to be under Section 3, or an institution specially empowered by an act. Correct? Because otherwise, Malaz, I can't just set it up.
Because of this provision.
Because of this provision. And C23, Malaz, that's the other thing. Please see 23. No institution, whether a corporate body or not, other than a university, established or incorporated by or under a central act, a provincial act, or a state act, shall be entitled to have the word university associated with its name in any manner whatsoever. provided that nothing in this section shall for a period of 2 years, we are not concerned with that. Then there's a big problem, Malaj.
So the right to establish a university
Yeah,
which is competent to award degree
yeah.
is restricted in terms of the provisions under the UGC Act, not on account of the judgment as such. In if you read in abstract.
Yeah, but Malaj, 1956
That's
was
what
there when
Basha
Basha was.
referred to this.
My problem is 1956 was there when Basha was established. And Basha then says, you could have set up a university and awarded degrees. Your Honorship will remember. That's what Basha says. That you could have set up a university.
In 1920, when
I agree.
Act was not there.
I agree, but even in 1920, there was no such statute. Even in 1920.
It is only 56.
He just said something. They just said it, Malaj. There was no statute under which I could have, Malaj, be called a university. It was not there then, it is not there today. And Basha doesn't say that it was there then. So the moment you say, because UGC now came into the picture, and UGC recognizes your degree, it doesn't recognize the establishment, Malaj. It's, Malaj, kindly see, the recognition is for a degree.
Degree is recognized by a university, not by UGC.
I'm talking about university, Malaj. Yes, it is recognition. UGC, Malaj,
University can
I
be
can't call myself a university, then the guideline.
At the moment,
University.
an entity is a university.
I lose my,
Loses its
I lose my status as a minority institution. That's what it is, because I can't say I have established it, according to Basha. Well, a degree to be recognized, ultimately, why is a degree given? It is given for the purposes of seeking employment. Well, let's be clear. Nobody gets a degree, whereas for the sake of having a degree. If it's medicine, for the profession, medical profession. If it's engineering, for engineering. If it's chartered accountants, law, it is only for employment. You have a BA degree, the minimum threshold for getting a job. You have to MA doctorate, you will get a teaching profession. So there is no degree which is unrelated to employment. That's another fundamental basis on the basis of which you must appreciate the whole case. So the degree is only a recognition of your attaining a certain expertise, academic expertise, to enable you to be part of the workforce of this country. It has nothing to do with the establishment of the institution. Without it, it is of no value. No degree is of any value. Supposing, Manoj, I want to set up a design institute, a minority institution. Can I be stopped? I can't. No, but I'll be regulated by the Act. Now, the moment I'm regulated by the Act and the minority says, look, I want to set up a design institute. Well, I'm regulated by the Act. Moment they give me the status of a university, I will lose my right to establish. Therefore, I'll not be able to serve the community for which I'm putting in money, for which I've given land. And in most of these cases, Mullah, the land is given by the community itself. So, Mullah, there's a complete disjunct in the concept of establishment and the concept of recognition. Complete disjunct. Recognition is for the purposes of being part of the workforce of this country. Establishment is for the purpose of ensuring that people of your community can be part of the workforce of this country, are enabled to be part of the workforce of this country, are empowered to be part of the workforce of this country. It's a vehicle for empowerment, not a vehicle for destroying the very concept of setting up or establishing a minority institution. So assuming now it's not a minority institution, what will happen, Mullahs? If it's not a minority institution, they will pack it with their own people. Not that they've done it, Mullahs. I'm not saying, Mullahs, that they are biased against us or that they will do it, but they have the right. They have to run it like any other institution of their choice. So they can have their own faculty, they can decide on how people are to be recruited, they can decide all that. I can't even choose the courses I want to study, Mullah. That has to be also cleared. So once I have established this fact, Mullah, then the question arises, what then, as I said, what are the indicia for establishment? And I just want to take your lordships to volume. Yeah, it's 4C, I guess. PDF 40, Mullah. Yes, PS 40, Aligarh Muslim University Bill, Volume 4A, PDF 40. Four C.
4C.
4C, what is it? It's 4C. Give me what are you waiting for?
PDF 40, this is the start.
Yes, sir, having after a careful study of the Indian political conditions, arrived at the conclusion that the backwardness of his community was due to their neglect of modern education, that selfless patriot Syed Ahmad organized a committee to divide means for the educational regeneration of Indian Muslims. This devoted band of Muslim workers held a series of meetings, the last of which took place on 15th April 1872, in which it was decided to establish a Mohammedan college, and on the 12th of May that year, a society called the Mussalman Anglo-Oriental College Fund Committee was started for collecting subscriptions for the realization of that end. The result of their patriotic activities was the establishment of a school, the opening ceremony of which took place in 1875 on the birthday of late Majesty Queen Victoria, 24th of May. The school classes being actually started on the 1st of June. His Excellency, the Earl of Northbrook, was then at the helm of the Indian government, demonstrated his generous interest in the welfare of that infant institution by subscribing a sum of 10,000 from his own pocket towards the fund. In 1876, high school classes were opened, and it goes on like that. That's the genesis. Now, let's kindly come to the bottom of page 41. The last 7 lines, starting with the sentence, meanwhile. My lords have that? Meanwhile, the movement for the establishment of a Muslim university continued to gather strength. Resolutions in that behalf were carried at several meetings of All India Mohammedan Educational Conference, and finally, having ascertained informally that in addition to the existing valuable assets of the college, a large endowment fund would be required as a guarantee of its stability before government would agree to the establishment of a Muslim university. Exactly what the UGC does now. His Highness, the Aga Khan took the lead and headed a deputation which early in the year 1911 visited the various Indian centers in order to collect the necessary endowment fund. Such was the general response of the Muslim community throughout India. Flat within a few months, the deputation secured realization of promises for a necessary fund of 30 lakhs. And remember, Maharaj, that 30 lakhs became then the endowment when Maharaj, the government decided that, look, you can, yes, under the 1920 Act. Now, Maharaj, none of this is discussed in Basha. None of this. On the 10th of June, 1911, the Government of India communicated to the Secretary of State the desire of the Muslim community and recommended that sanction might be given to the establishment. Sorry, Maharaj. I don't stand here, Maharaj, for Aligarh Muslim University. Maharaj, I stand here for the diversity of the constitutional ethos of this country. And I plead to your lordships, don't allow that to be destroyed. There's no such thing as one size fits all, especially in the field of education. Whereas, I mean, I have some idea as to how educational institutions are set up, Mullahs. I mean, they're not set up by a statute, just like that. Mullahs, somebody says, some representative says, Mullahs, I just give lordship the reality. Some representative says, I don't have any school in my area. You know, my people have to actually rush 25 kilometers. My girls have to go 25 kilometers to go to a school, or 40 kilometers or 50 kilometers. There are no teachers. We need a school here. And then, Mullahs, representations are made to public representatives. Then the matter, resolutions are passed. Then, Mullahs, the matter comes to the minister concerned. Then the minister looks at all this. The minister then says, look, let's find out whether at all it's feasible to have a school there or not. Then ultimately, Mullahs, a decision is taken. Then the file moves from the UDC to the LDC, to the director, to the joint secretary, to the additional secretary, to the secretary. Then a cabinet note is prepared. Then the cabinet note is circulated. Then discussion is with the finance ministry. Who's going to finance it? This is how Mullahs institutions are set up, not by a statute. The statute is the end product of the establishment process, which starts on the ground. And this is that establishment process that I am, Mullahs, inviting my Lord's attention to. It is at the heart of establishment. Statute happens to be a vehicle for the purposes of recognizing the establishment. It is not the establishment itself. It can never be as a matter of law. My land, my money, my community, my desire, my infrastructure. But moment I get, say that, look, the statute recognizes it, I lose everything. I am nobody. And why is it an institution of national importance? Because there was no other university, minority university at that point in time. Needed help also. Non-Muslims also ultimately gave funds to it. We also stand there and defend it, Maharaj, because we stand for that ethos. Yeah, I know that. That's mentioned already. So,
in fact, this particular debate, the debate in the legislature, refers to the Banaras Hindu University as well.
Yes.
And at page 42.
Yes.
Meanwhile, the Hindu leaders who too had their in turn approached the government of India with a scheme for the establishment of a Hindu university at Banaras.
Yes.
Guided by that practical spirit, which is one of their characteristics, accepted the conditions laid down by the Secretary of State, with the result that a bill for the establishment of the Banaras Hindu University was prepared, etc. Then they say, the legislation regarding the Banaras University was framed in consonance with that scheme of things. The bill, that is this AMU bill, is in its essentials founded on the Banaras Hindu University Act,
Correct.
recognizing the all India character of the Banaras and Aligarh universities. The rules framed under the new Government of India Act have now proposed that these two universities should be a central subject, and the responsibility in connection therewith will thenceforth be rest on the shoulders of the Government of India.
Yes. Therefore, Maharaj, they couldn't be in list 2. They had to be in list 1. And Maharaj, list 1 is only fields of legislation. That's all that there is. And so if in that field of legislation you do something which interferes in my administration, I can challenge it. Whereas even in the 1990 Government of India Act and the 1935 Act, they were in list 1. So we did not, our constitution did no different. Then come to 45 minutes. Now, well, kindly see at a glance, kindly come to 43 bottom minutes. I'm sorry, not 40, 43 bottom. It's in quotes. A glance at section 6.2, 17.5, 18.5, statutes 8.1, 10.1, and 19.1 of the BHU Act will make it clear to honorable members that the visitor, the Lieutenant Governor of the United Provinces, is the main agency of control in the case of the Banaras University. In the present bill, in consonance with the central nature of the subject, much of that control is transferred to the Governor General in Council, an authority which under the Government of India Act will henceforward include 3 Indian members. Under the Banaras Hindu University Act, all new statutes or additions to statutes or amendments or repeals to statutes other than those providing for the instruction of Hindu students in Hindu religion require the previous approval of the Lieutenant Governor. And your lordships will notice that the court under the BHU Act consisted all of Hindus, which was also amended later. This can't be done, just as the all-Muslim court was also amended in 1951. Then come to 45. Well, this is Honorable Khan Bahadur Mir Asad Ali Khan, second paragraph. By the introduction of this bill, we are adding today one more university of a teaching and residential type. University education on modern lines will prove to be a great boon to the Indian Muslim community. The Aligarh University, when it ushered into existence, will undoubtedly be an epoch-making event in the history of the progress of Indian Muslim education. With the door of universal knowledge wide open to the Muslim young men in a university of their own, the intellectual progress of the Muslim community is assured. With the imparting of Muslim religious education in Muslim young men and direct encouragement of Oriental and Islamic studies, their moral and spiritual progress is assured. In one important respect, the proposed university at Aligarh will differ from the existing universities of a teaching and residential type in that it will not, as recommended by the Calcutta University Commission, include intermediate classes. Greater concentration will be given to the development of cultural aid of higher liberal education. So here is a minority institution wanting to concentrate on liberal education. Now, can this be ignored, Malas? Kindly see, Sir Bhadikari. Sir, I congratulate, page 46. My Muslim fellow subjects, upon the appointed time, having arrived upon the approaching materialization of an educational organization of their own for which they have long been waiting. Materialization, this is establishment.
I was reading a little differently. Did you read that passage at page 45 from Khan Bahadur Mir Asad Ali Khan's speech?
Yes.
By the introduction of this bill.
Yes, I read it. I just read it. I just finished reading it. It is for the empowerment of the Muslim community, that's all. And that's also in liberal education. All this, Basha doesn't deal with, doesn't talk about. but it goes only on one thematic. And Mullahs, actually, I have, and I'll give it back to your lordships tomorrow morning. I'll finish Mullahs early morning tomorrow. Mullahs, I have analyzed the various provisions of the Aligarh Muslim University Act, Mullahs. All of that Basha refers to are matters of administration. I tell you, lordships, the mistake that was committed by the petitioners in Basha's case, when they found that the judge was not agreeable to the fact that it was established by the Muslim community, they started arguing, doesn't matter. Even it was not established, it was administered. Which is contrary to 30. So, Mullahs, therefore, the reference you will find established or administered. Why? Because they argued, I am a minority institution, even if I am not established as a minority, but I have administered it. Aligarh Muslim University was not there before the court. That's why that reference was made to that or. Because the genesis of which is the following, I'll just briefly in a few minutes tell your lordship the genesis. This happens in 1920. Then, Mullahs, the UGC Act comes. I am a minority institution. Then the 1951 amendment happens. Basha says irrelevant. That amendment is irrelevant. Doesn't take us anywhere. Then the 65 amendment comes. Like that 65 amendment, Mullahs, Chagla in Parliament says this is a temporary measure. I'll give that passage. So, Mullahs, nobody agitated. A PIL petition was filed challenging the 65. I didn't file it. Aligarh Muslim University didn't file. PIL petition was filed. Came Basha's judgment in 1968. Despite Basha's judgment in 1968, Mullahs, nothing really happened. The university continued as it was. Muslims, everything, 100%, all that happened, Mullahs. Then, Mullahs, what happened was that in November, Justice Fazal Ali, with reference to Anjuman, Remania, Mullahs, said that somebody relied on Basha. I said, this needs reconsideration. This is in November 1981. The amendment came in December 1981, 31st December 1981, immediately thereafter. Then came the 82 Act, 81 Act. Again, minority, nothing happened. It continued like that, Mullahs. Then in 2005, I'm just giving you, Mullahs, just a conspectus of what happened. In 2005, now, till that time, Aligarh Muslim University was not involved in this litigation at all. In 2005, of the East and the West, my lords, and the serving the cause of Muslim community. So page 46, my lords. Sir Bhadikari, sir, I congratulate my Muslim fellow subjects. So, my lords, this goes on. I mean, I can go on ad nauseum, but I don't want to waste your lordship's time. Then come to 51, my lords. The Raja of Mahmudabad. Sir, on behalf of the Muslim community, I beg leave to offer our grateful thanks to His Excellency the Viceroy and the Honorable and the Muslim University at Aligarh a tangible shape for giving to the proposal for the establishment of a Muslim community, establishment of a Muslim university at Aligarh in tangible ways, shape. Sir, even ever since the days of the foundation of the Aligarh College, it has been the heartfelt desire of the Mohammedan community to found a university center. Well, as my learned friend, Dr. Dhawan talked about founding. So it's really, it is the meeting of minds of the community for the purposes of taking forward the idea, which then ultimately results in a university being set up, is what establishment is.
What you're really saying is object and purpose has to be taken into consideration when we examine the word
Exactly.
established.
The genesis.
What is the purpose of establishment?
Yes, the whole idea, the genesis of why it was done, that's the basis, brothers. That's what established means. The rest is on recognition only.
Legal establishment has to be in terms of law.
Exactly.
What's that policy?
That's right.
Stipulated.
But that's not the expression establishment in Article 30. It is not legal. Your Lordship, I think Your Lordship has put it very well. It is not the statutory recognition which is at the heart of establishment. That's a legal interpretation. Legally, it can't be established any other way. Can't be set up any other way.
In a society will have to be registered under.
Exactly.
Association again.
Exactly. So Basha loses sight of all this completely. This is not the only thing, but if I give your lordships, just give me 1 second. Kindly see this volume of 3C. Yeah. Well, just kindly come, because every speech is exactly the same, congratulating the Muslim community and their efforts. Now come with us to volume 3C.
In fact, it's called the second denominational
That's
university.
it's like denominational university.
You'll find that at page 51.
That's correct. That's right.
That is a speech of
That's
the Raja of
where the
Ahmedabad.
Banaras Hindu University also. It applies to both.
Yes.
Now, let's kindly come to, because I can go on and on, there's no point. I've just given to your lordships a flavor as to how the genesis ultimately reflects itself in what was happening at that point in time. But kindly see, much before that, in 1872, Mullahs, there's a letter from the Viceroy to Sir Syed, which your lordships will find in volume 3C at PDF page 56. This is the private secretary to the Viceroy writing to Sir Syed. This is volume 3C, Mullahs, page 56, PDF 56. Well, let's kindly come to that letter. This is the secretary to the Viceroy, to Sir Syed. Kindly come to the second paragraph. Lordship has that? Kindly come to the second paragraph. Well, it's middle of the paragraph, but I am desired to inform you. Lordship has that?
Yes.
But I'm desired to inform you that if the committee succeed in establishing the college, if the institution when established shows a reasonable prospect of divisibility and general success, and if the course of instruction is such as to convince His Excellency that a really bona fide effort is being made to afford such sound secular instruction, he is prepared to devote 10,000 rupees to the perpetual establishment of a scholarship in some branch of European literature or science. Should this scholarship be ultimately established, the details connected. Then, let's come the selected, kindly come now to page 64. Same volume, page 64. From Sir Syed to Eliot, in reply to that letter that I just read to your lordships. At page 64, and second paragraph. And let's not forget the fact that Basha says, because you're not established, nothing else arises. That's what Basha says. So we don't have to go into anything else. He says, you've not been able to prove that you established because there's a statute. Therefore, you're not a minority institution. So nothing else arises. Then comes the argument, I think completely erroneous, that even if we are not a Muslim university or established as a Muslim university, we are administering it. Wholly irrelevant. But let's kindly see the response at page 64, second paragraph. Certain Mohammedan gentlemen who were desirous to see the education of their co-religionists placed on a better and sounder footing organized a committee on 26 December 70, designated the Committee for the Better Diffusion and Advancement of Learning among Mohammedans of India, with a view to ascertain why the Mohammedans of India do not avail themselves of the government system of education, and to suggest means for the removal of obstacles, if any, and also find out why the study of Western sciences did not gain favor with them. So they were trying to move out of the madrasa culture. That's what Sir Syed was trying. Well, see the patience of that man. We're talking about the 19th century. To elucidate the points above alluded to, the committee invited essays offering as an incentive to competition 3 prizes of 500, 300 each of 3 best essays. The above sums have been previously collected by subscriptions raised for the purpose. And then, page 65, the paragraph starting the proposal of the select committee as set forth above, with the approval of the Central Committee, and the latter passed a resolution in the meeting held on 12th May 72 to the following effect, that a committee be appointed to raise funds for the establishment of a college in the NWFP for the Mohammedans, which would meet all their requirements, and the committee be designated the Mohammedan Anglo-Oriental College Fund Committee. Subscriptions have already been set on foot, and rules for the safe custody of the sums thus raised framed by the committee. A copy of these rules, having thus most deferentially represented the main facts, the committee hopes that their efforts may meet the approbation of the government, and takes this opportunity to express a hope that the government will be graciously pleased to afford that help. And then, my lords, kindly see the next, the very next page, 66. The deplorable state of ignorance into which the masses of the Mohammedan community of India had of late fallen, having attracted the attention of some of the enlightened Mohammedan gentlemen of the country. And a committee was formed about a year ago to consider upon the best means to diffuse useful knowledge amongst the masses and to direct their attention towards their own amelioration so that they may be enabled to keep pace with the rising age. The said committee, after full consideration, after a long debate, carried out a thorough, out through several meetings, have now resolved to establish a college in the for the special education of Mohammedans. Now, let's kindly have a look at page 87. PDF page 230, is it 230? 87, very interesting. They decided to set up a college, Millers, and see the courses of study. Page 87.
Where does that document begin?
Millers, it begins at page 77. It says,
It's again a scheme for the proposed Mohammedan.
yes, well, it's very interesting, Millers. I can go on reading, but I just give your lordships a bird's eye view of the mind of Sir Syed. What was he looking at? If you look at page 84, it says, the school course is to extend over 5 years and will include Persian language, literature and composition, arithmetic, algebra, elements of Euclid, history of India, geography, English, religious instructions, and Arabic, which is voluntary. And then you will find boarding students will have to observe discipline, which the headmaster may think proper. And the staff of teachers may consist of headmaster, teacher of English, teacher of Arabic and Mohammedan theology, teacher of mathematics, Persian, history and geography, handwriting. And then you will find, most interesting, Millers, page 87, course of study for the lower department of the college will be Arabic, English, Sanskrit, Latin, and Greek. Mathematics will be theory of equations, algebra, plane trigonometry, spherical trigonometry, conics, solid geometry, differential calculus, integral calculus. This is how it has become an institution of excellence. I mean, when I went to Cairo, Millers, on several occasions, it is talked of all over the world. Al-Azhar University, Millers, full of people. Now, why do you want to destroy this legacy? It is, I know that. Why do you want to destroy it? And Millers, I have a legal issue, Millers, which I am really concerned about. I'll assume that Act 81 Act is bad. But it's bad. It's still a parliamentary statute. It's void, fine. Can a government ever make a submission to the court contrary to a parliamentary statute, even if it is declared to be void? It must support it. An executive cannot go against a parliamentary statute, even if it is struck down. It's struck down every day. When statutes are struck down every day by the High Courts, can a government say, I will go against the statute? This is the first time it has arisen, Millers. Having otherwise supported it, they say the executive can change its mind. Of course, it can change its mind by an executive decision. But it can't change its mind by a statute which Parliament has passed and say, no, I will argue against the statute. It's another very serious issue, Millers. No, I'm not saying you decide or not decide. There is a parliamentary act.
I'm ready to answer this.
No,
Let 81 amendment be decided. I will, my lord, argue against 81 amendment and
how can you?
substantiate it.
I mean, I have
can't say that don't touch 81.
how can you argue against
this
the
argument
amendment?
also.
This is an amendment of parliament. You cannot argue against it. An executive cannot argue against a statute which is passed by parliament.
In a constitution bench, it is the duty of the government to assist the court in the correct possible manner.
I'm
It
sorry.
was struck down by the High Court. I
don't-
can always support
I
the High
don't-
Court's view.
I don't know
But then
what
you
was-
can't say separate,
We have understood your argument.
don't permit arguments on 81.
We have
but
understood
will-
that argument. It was also flagged by Dr. Dhawan. It was flagged by Dr. Dhawan.
No, he talked about I'm talking about.
He flagged it, but he said after they raise the plea, then in rebuttal, I'll take it up.
Yeah.
We have understood that. But
So, Maharaj, I'm just saying, this is the mind of these great people in the 19th century. This is what they were looking at. And that's how the whole thing came into being. And that is why, Maharaj, it was established by the Mohammedan community for the purposes of empowering them to be part of the workforce of this country in various disciplines. And all that we get from it is a certain amount of reservation. Beyond that, we are all subject to the control. So, Maharaj, that's on established, Maharaj. Now, Maharaj, I just want to take your lordship. Huh? Where is that? PDF 4. The Kerala Education Bill, PDF 62, Maharaj. My learned friend has read everything, so I'm not going to, Maharaj, unnecessarily waste your lordship's time. Volume 5A, PDF 62. And that's all right. I don't want to go on. Just.
Yeah.
Lordship has that?
Dr. Dhawan has shown us the judgments, Mr. Sibal. We can just look at them and you can formulate your point. On
No, I just show one sentence, Maharaj. I'm not going to read the judgment. Just one sentence. Kindly see.
Volume 5A, right?
Yes, 5A, page 62. The key to the understanding, Maharaj, this is the paragraph about towards the lower half, sentence starting, the key to the understanding of the true meaning and implication of the article under consideration are the words of their choice. My lord has that?
Yes.
Yes. Now see the next sentence. It is said that the dominant word is choice, and the content of that article is as wide as the choice of the particular community, minority community may make it. Sorry, Maharaj, it's at page. I'm sorry.
Page 62.
Yes,
The key
page-
to the understanding of the true meaning.
Yes, Maharaj. This is
About 10 lines from the bottom.
yes. It is said that the dominant word is choice, and the content of that article is as wide as the choice of the particular minority community may make of it.
Yes, we read this with Mr.
Yes, but I mean, I'm.
Yeah, flagging it again. Yeah.
Yes, I'm flagging it for the reason is what I started with. That choice is mine. It is as wide as the content as I would like to have it. It is true for establishment, it is true for administration. The ambit of the rights conferred, the next line, the ambit of the rights conferred under Article 30, brackets 1, has therefore to be determined on a consideration of the matter from the points of view of the educational institutions themselves. So, how do you view that right? You view that right through the eyes of the educational institution. What is that right? It is as wide as the content. The choice is as wide as the content of the article. And that choice cannot, subject matter, I cannot do something for an illegal objective. I cannot do something that is otherwise prohibited by law. That is obvious, matter. I will not, my choice will not extend to that. My choice will not extend. But within the framework of the law, the choice is mine. And within the framework of the law, I can set up a university. Therefore, that is absolute. What is not absolute is that I can be controlled through regulation, which flows from 1906, which is the public interest argument. That is why, sorry.
Yes.
Therefore, that's what I'm saying is now, India Education Bill was in year 80.
58. Kerala Education.
Yes,
Bill.
Kerala 58. Right, now let us kindly see, so the law was already there. Kindly see Siddharth Bhai now. Just again, I'm not going to read the judgment, just one or two lines. At 106. This is, Siddharth Bhai explains what that absolute right means, Manoj, which has not been understood so far. It says, Manoj, at the end, the last at page 106, last 5 lines. Unlike Article 19, your Lordship sees that? Unlike Article 19, the fundamental freedom, but my Lords, I'm sorry. My Lord, the Chief Justice had?
Yes.
Unlike Article 19, the fundamental freedom under Clause 1 of 30 is absolute in terms. It is not made subject to any reasonable restrictions of the nature the fundamental freedom enunciated in 19 may be subjected to. All minorities, linguistic or religious, have by Article 30 an absolute right to establish and administer education, and any law or executive direction which seeks to infringe the substance of that right would be to that extent be void. Now, as I just came to what my Lord put to me. That right in yours and me, I can challenge interference. I can say this structure is fine, you can have a doctorate, you can have a UGC representative, I have no problems with that. But I should have that grievance, because the right is mine. But under 19 minutes, that right is subject to the regulations under 19. Because it's an occupation. And for that occupation, I am subject to government regulations, either through the UGC or even otherwise. Next sentence. This, however, is not to say that it is not open to the state to impose regulations upon the exercise of this right. There it is. The right is absolute, subject to regulations. The fundamental freedom is to establish and to administer educational institutions. It is the right to establish and administer, which are in truth educational institutions which cater to the educational needs of citizens or sections. Regulation made in the true interest of efficiency, of instruction, discipline, health, sanitation, morality, public order, and the like may undoubtedly be imposed. Such regulations are not restrictions on the substance of the right, which is guaranteed. They secure the proper functioning of the institution in educational matters. So your Lordship now see the correlation between 19.6 and 30. The absolute right under 30, subject to regulation under 19.6. But that is for efficient standards. And the dual test for excellence is set out here, Maharaj, my learned friend, in Siddharth Bhai. That's page 114. Where he says, making the institution an effective vehicle of education for the minority community or other persons. So, I've done with Siddharth Bhai. Then you come to TMA Pi, Maharaj. This is very important. Kindly come to, several parts have been read of TMA Pi, but kindly come to page 650. I'll come to that later. Paragraph 138, it's very important.
650.
615.
649, para 138.
These are all read over.
You've read this one.
He read it, Maharaj, but I just want to. Because it fits into the initial submissions I'm making, that's why I'm reading it. It says, as we look at Article 30, 30 is a sort of guarantee or assurance to the linguistic and religious minority institutions of their right to establish and administer institutions of their choice. Secularism, and forget the secularism part. Now, let us kindly see last sentence. Any law or rule or regulation that would put the educational institution run by minorities at a disadvantage when compared to the institutions run by others will have to be struck down. So you can't discriminate. Two, at the same time, there also cannot be any reverse discrimination. It was observed in St. Xavier's, the whole object of conferring the right on minorities under Article 30 is to ensure that there will be equality between the majority and the minority. If the minorities do not have such special protection, they will be denied equality. This is now confirmed by 11 judgment.
Yes.
So that protection is essential. That's the heart of 30. In other words, the essence of 30 is to ensure equal treatment between, and how do you get that equal treatment? By virtue of 30.
Yes.
Otherwise, Maharaj, you'll not be protected, my minorities will not be. That's true of others also, Maharaj, I'm not saying that. Why did Maharaj, I asked myself the question, Parliament amended the Constitution, included weaker sections of the community, EWS. Why did they do that? Because many members of the forward community, of the advanced communities, were still poor. They had no access. And therefore, Maharaj, a special reservation was given. I was like, I'm against it, but that's another matter. Special reservation, because the Constitution only talks about classes of people. But we are not concerned with that. So this is then what happened, Maharaj. So if you do not interpret 30 in this fashion, and say that, look, you have lost your right to establish, what you're doing is you are in fact violating the right to equality, which is a violation of 14 in fact. Some other parts of education, at 19, huh? Para 18, yes, that's very important. Para 18. Para 20, actually. It starts at 18. This is the submission that was made.
And then we will have to.
At page 604.
In a page,
page number 604. I'm sorry, my lords have that?
yeah.
With regard to the establishment of educational institutions, 3 articles of the Constitution came into play. Article 19(1)(g) gives the right to all citizens to practice any profession or to carry on any occupation, trade, or business. This right is subject to restrictions that may be placed under 19(6). Then 26 gives the right to every religious, we are not concerned with religious denomination for religious purposes. Then Article 19(1)(g) and 26 therefore confer rights on all citizens of religious denominations to establish and maintain educational institutions. There was no serious dispute that the majority community, as well as the linguist and religious minorities, would have a right under 19(1)(g). This is the point I was trying to make, which is what I argued mullahs in TMFI. I said they have equal rights. And 26 to establish education. In addition, 31, in no uncertain terms, gives the right to the religious and linguist minority to establish and administer educational institutions of their choice. So it is a right under 19(1)(g). There is an additional right under 31, which protects the minority community to seek to empower them. Why? Because otherwise, if we don't give them that right, it will result in article violation of 14. So St. Xavier's is mullahs affirmed by 11 judges. I've basically done almost everything. Not going to waste your lordship's time.
After that, Mr. Farasar? Half an hour, and then we'll call upon, who will commence from the,
Very short.
Mr. Sibal, then Mr. Salman Khurshid, and then Mr. Farasar. Give us a one-page set of submissions so that we'll upload it.
Well, there's another item that I won't uploaded, only giving the sections of the act and all that. We've already given it, all that to be done.
So a little before lunch, I think by about 12:15 or 12:30, we'll be calling upon the other side.
Yes, that should be a problem. Please. Deeply obliged, deeply obliged.
Right.